The Clerk will now proceed to read the orders of the day.
Employment Rights Bill, as amended in the Public Bill Committee, to be further considered.
Now, we will begin with Clause 39, with which it will be convenient to consider new clauses, amendments and new schedules as listed on the selection paper for Day 2. I call the Minister to move new Clause 39. Minister Justin Madison.
Thank you, Madam Deputy Speaker. I beg to move that the clause be read a second time. First of all, can I declare my register of interest, membership and financial interest in trade unions, as I have done throughout the passage of this bill? And can I thank all members in all parts of the House for their contributions to yesterday's debate? I look forward to another good debate today as we work together to ensure this bill works in practice for workers and businesses of all sizes across the whole country. Similar to yesterday, I will use my opening remarks to explain to the House the amendments put forward by the Government in parts 4 and 5 of the bill. The Government is moving a number of amendments which represent a significant step forward in modernising our industrial framework. Amendments to Clause 50 will strengthen the provisions of trade union access right. They will ensure the framework functions effectively and deliver on our commitment to modernise working practices. They will streamline access provisions by allowing a single CAC member to make a fast-track decision on whether access should take place. In making a decision about whether it is a single person or a panel who will consider the application, the CAC will be required to have regard to the complexity of the case, as well as whether the proposed terms of the agreement are model terms, various criteria which will be prescribed in secondary legislation following consultation. They will also clarify that supporting a worker is a legitimate purpose for access and provide a power to bring forward secondary legislation to make further provision as to how the CAC is to determine the level of penalty fines for non-compliance with access agreements. And it will expand access rights, enabling access agreements to cover communicating with workers in ways that don't involve entering premises, for example, connecting digitally using technology, therefore modernising our antiquated industrial relations framework. New Clause 39, new Schedule 2 and associated amendments insert new provisions into the bill, replacing Clause 51, and will address unfair practices and access arrangements in the recognition and de-recognition process. They will extend the application of unfair practice protections to the point at which the CAC accepts an application for recognition or de-recognition and ensures employers cannot increase the size of the bargaining unit for the purposes of the recognition application after the application is made. This will end the deliberate gaming of the system that we have seen in recent years. It will also delete the second test for determining an unfair practice complaint, which currently requires the CAC to consider how an alleged unfair practice may have affected workers' votes in the recognition or de-recognition ballot. It will extend the time limit in which unfair practices can be reported after the ballot closes to 5 working days. It will ensure that an employer cannot recognise a non-independent trade union after receiving a request for voluntary recognition from an independent trade union as a means of thwarting the independent trade union's subsequent application to the CAC for statutory recognition. And it will bring forward and formalise the process for agreeing access arrangements between the employer and the union during the recognition and de-recognition process. These amendments will streamline the recognition process, reduce opportunities for unfair practices to occur, and ensure unions seek recognition have a fair and transparent statutory route to enable them to do so. Today's amendments in terms of industrial action rules will reduce the costly, complex and bureaucratic requirements on unions in relation to industrial action and ballot notices, whilst ensuring that employers have the necessary notice and information to prepare for industrial action. New Clause 42 will simplify notices to employers of industrial action ballots and industrial action, reducing the chance of spurious challenge and making the information required more proportionate. New Clause 43 will extend industrial action mandates from 6 to 12 months, reducing the need for repeated ballots, and amendments to Clause 61 will mean the notice period for industrial action will be set at 10 days, giving businesses time to prepare while safeguarding workers' rights. Amendments to Clause 58 mean that the 50% ballot turnout threshold repeal will be subject to commencement on a date to be set in secondary legislation. Turning now to political fund ballots, new clause 40 and associated amendments remove the requirement for unions to hold a ballot every 10 years on maintaining a political fund. Instead, unions will provide reminders about members' right to opt out every 10 years, ensuring transparency without imposing costly and time-consuming ballots. Moving now to the Fair Work Agency, the bill will bring together the various agencies and enforcement bodies that enforce employment rights into the new Fair Work Agency to ensure that where employers are not doing what is right, a simplified and strengthened enforcement system will protect workers and ensure justice in the workplace. The Fair Work Agency needs to have the right tools to do the job. This is a series of amendments that forms a package that will give the Fair Work Agency those tools that it needs to hold all employers to account more effectively. That is fair for workers and it is fair for businesses too. The Government is moving amendments to introduce new powers that are key to the Fair Work Agency's core enforcement role. New clauses 44 to 56 create a civil penalty regime. Under this regime, enforcement officers will be able to issue notices of underpayment and impose a penalty on employers where they have underpaid individuals in breach of statutory pay rights that are within the remit of the Fair Work Agency. As a result, the Fair Work Agency may be able to help workers get the money they are owed more quickly than if they had to go through an employment tribunal. But in other cases where proceedings before the tribunal are necessary, we want the Fair Work Agency to be able to support individuals and ensure the tribunal's time is used as effectively as possible. New clause 57 does that by enabling the Fair Work Agency to bring proceedings before the employment tribunal if individuals are unwilling or unable to. Under clause 58, the Fair Work Agency will also be able to offer and advice assistance to individuals bringing employment-related cases before the courts or tribunals. The Government is also moving amendments to upgrade the powers the Fair Work Agency will need to tackle labour abuse effectively. The committee heard from stakeholders including Eleanor Lyons, the UK Independent Anti-Slavery Commissioner, about bad practices in the social care sector, but currently the Gangmaster and Labour Abuse Authority is prevented from investigating many cases because they don't meet the modern slavery threshold. The Fraud Act covers situations that amount to labour abuse but actually fall short of modern slavery. So today we are bringing forward two amendments which will deliver the Government's commitment to give the Fair Work Agency the strong powers it needs to tackle labour exploitation. Firstly, we will enable the Fair Work Agency enforcement officers to use their powers to investigate such cases, helping the Fair Work Agency to protect the most vulnerable in the workforce. And further, we will give enforcement officers the ability to issue special warnings following arrest. In practice, that means telling suspects that if they refuse to answer questions about certain items or their whereabouts, this could be used against them in court.
On that point,
yeah.
I'm grateful to my honourable friend for giving way. There's only been 21 employers prosecuted for national minimum wage violations since 2007. The measures that he's bringing forward, I think, will improve enforcement, but he touched on the Modern Slavery Act. He didn't address the points that were made in the debate yesterday. Will he now use this opportunity to say a little bit more about the Government's intention to update the Modern Slavery Act?
Minister.
I'm grateful for the Shadow Select Committee's interventions. I think we do accept that there are gaps between the modern slavery network enforcement processes and indeed what we currently have in terms of employment rights enforcement. So we are working with the Home Office and the GLAA to improve that. These are things that we can continue to work on in due course as we develop the scope and remit of the Fair Work Agency. And as well as reforming and strengthening the powers, the Government is moving amendments to expand their remit of the Fair Work Agency to ensure effective enforcement of statutory sick pay and holiday pay. Today's amendments will bring Northern Ireland SSP legislation into the scope of the Fair Work Agency and introduce a requirement for the Secretary of State to obtain the consent of the Northern Ireland Executive before bringing any further devolved legislation in scope. Further amendments will bring the new duty in the working time regulations for employers to retain records relating to holiday pay and annual leave for 6 years within the scope of the Fair Work Agency. It is also the Government's intention for the Fair Work Agency to take on enforcement for new protections in relation to zero-hours contracts, which is subject to a consultation on the detail and the outcome of the spending review. New Clause 60 creates a power for the Fair Work Agency to recover the cost of taking enforcement action against businesses that are found to be non-compliant with the law. This is in recognition of the polluters pays principle and is similar to how other regulators operate, such as the Health and Safety Executive. And of course, we will consider carefully and discuss with businesses as appropriate before exercising this power. But we do think it's an important principle that where there is wrong, that the person in the wrong pays some contribution towards the taxpayers' costs in enforcing the law. So to sum up, Madam Deputy Speaker, I know there are many people eager to speak in the debate today, which will ensure workplace rights are fit for a modern economy, empower working people and contribute to economic growth. I urge members to support this bill and the amendments we are moving today, which will show that we are pro-business, pro-worker, pro-family and pro-growth.
Trade union recognition.
The question is that the new clause 39 be read a second time. I call the Shadow Minister, Greg Smith.
Thank you, Madam Deputy Speaker. So, ahead of getting into detail of the many amendments that we have before us this afternoon that the Minister rattled through in but 10 minutes, overnight we learnt that the government are moving the responsibilities of one quango to another. That is, moving the payment systems regulator to the Financial Conduct Authority, putting one quango into another which conveniently already share a building. The Prime Minister has hailed this as the latest step in the government's attempt to kickstart growth. And that is why it's relevant to the amendments we have this afternoon that do the very opposite. And the Chancellor said, the regulatory system has become burdensome to the point of choking off innovation, investment and growth. The precise things this bill does. I do not know how they can say this with a straight face when we today stand here with a £5 billion cost to businesses of blocking regulatory burdens on every business, small, medium and large in this land.
In the chamber yesterday, Madam Deputy Speaker, it was quite clear that the Minister and his team opposite didn't fully understand what the definition of a small business was. I'm sure that my honourable friend on our front benches absolutely does understand. And does he agree with me? This is fundamental to understanding why the balance of this piece of legislation is wrong.
My right honourable friend makes a superb point, as she always does. Certainly every single small business in my own constituency that I talk to are very, very concerned about the measures in this. Well, I will give way to the Minister if after 24 hours later he is actually able to name a small business that supports this bill.
So 24 hours to
well, I'm asking the Minister to give Shadow Minister to give way because, of course, the backbencher could have intervened on me during the time I was speaking. But one of the reasons why there's so much confusion about a small business is because the Shadow Minister actually moved an amendment in Bill Committee to define a small business as being an organisation or person employing 500 or more employees. So if there's any confusion, it's on that side.
the best you can do.
24 hours later, and he still can't name a small business that supports this bill, Madam Deputy Speaker. It shows how out of their depth this trade union government actually is when it comes to supporting the businesses in this land. In the words of the Chancellor herself, this bill is choking off innovation, investment and growth. To pretend otherwise, they are taking the public for fools. So, Madam Deputy Speaker, I turn firstly to new clauses 89 and new clause 90. Almost everything this government has done is contradictory to the objective of growth, if that remains their objective this week. Whether it is the National Insurance Jobs Tax, the changes to business rates, or this bill itself, everything seemingly goes against growing the economy. It is therefore little surprise that under Labour, the economy is flatlining. The Prime Minister said earlier this year, he said that everything the government does will be subject to a growth test. However, the details of this test have been sparse at best. So sparse, in fact, that you may well think it doesn't exist. And there is no greater evidence...
Will he give way?
I will give way.
Mike Martin.
I thank him for giving way. Could he describe Liz Truss's growth test?
Well,
cut red tape
for a start. But I think what we see from the I think what we see, Madam Deputy Speaker, from the Liberal Democrat benches is that the orange book tradition of the Liberal Democrats is well and truly dead, and they now position themselves firmly to the left of the Labour Party. There is no greater evidence that the growth test does not exist than this bill itself. For if such a test did exist, this bill would fall at the first hurdle. But today, I come with good news. For I have two amendments that they can back this afternoon. Two amendments that will help them to grow the economy. Those amendments are, of course, New Clause 89 and New Clause 90. New Clause 89 will require the certification officer to advance the objectives of the international competitiveness of the economy, and New Clause 90 will require the Secretary of State, not in his place again today, to have regard for international competitiveness when passing regulations under Part 4 of this bill concerning the trade unions. The government has been asking regulators for ideas to boost growth. Contradiction in terms to ask the regulator to boost growth, but we are happy to help them on their quest. These amendments should be the ones that the government can support. If the government can't support these amendments, it shows that they are not serious about economic growth. And more tellingly, it shows that they do not intend to use the powers in Part 4 of this bill to achieve growth or international economic competitiveness, because they do not intend to exercise the powers compatibly with these objectives. So, Madam Deputy Speaker, I move to New Clause 88. It is one that I'm sure will get them a little bit hot under the collar regarding trade union political funds. For this government is a Labour Party first, country second government. Nowhere is this clearer than in the changes that the government are making to the political fund with this bill. Let us be in no doubt. These changes are designed with one simple purpose: to bolster the coffers of the Labour Party. Clause 52 will mean that members of trade unions will automatically contribute to their trade union's political fund without being asked about it first. They will have to opt out rather than, at present, opt in. If trade union subscriptions are Did someone want to try and defend that? No? OK. Clause 52 will mean that members of trade unions will automatically contribute to their trade union political fund without being asked about it. If trade union subscriptions are to be used for party political campaigning, it should be a conscious decision of the trade union member to endorse such campaigning. And I'd be delighted.
The Shadow Minister may recall from the Bill Committee that every single Labour member of that committee declared sponsorship from the trade union movement. And does the Shadow Minister agree with me that this clause is simply payback for the trade union movement for their financial support for the Labour Party?
Greg Smith.
My honourable friend served assiduously during the course of the Bill Committee, raising many good points, including the one that he just made that I absolutely agree with. And the public will be asking serious questions about this. If the honourable gentleman wants to try and defend this, I will give him the opportunity.
My interest, Madam Deputy Speaker, as a member of 3 trade unions. I got less than the honourable gentleman, the Shadow Minister, got from small business, which I think his declaration is 12,500. Did he feel the need to declare that, given he's now making a case against legislation that would impact that particular company?
Greg.
Madam Deputy Speaker, I'm making a point about the trade union movement, something that I have never been a part of and certainly never received any money for. But I'm happy for the honourable gentleman to look at all of my declarations in the register of interest.
Is it really a point of order?
Well, we can find out, Madam Deputy Speaker. I believe it is. On a point of order, Madam Deputy Speaker, could you advise whether those members opposite that receive money from businesses that are affected by this legislation should be making a declaration the same way that us trade unions are?
This is going to end up in a back and forth on things that aren't a matter for the chair. Declarations are the responsibility of individual members to make appropriately through the right processes.
Thank you, Madam Deputy Speaker. And for the avoidance of all doubt and all transparency, I will declare all of my entries in the Register of Interest for all to look at. They are all there for anybody to see. Once more.
Sir Julian.
This argument about opting in and opting out of trade union levies goes back at least to the 1970s and probably beyond, when I remember arguing about it as an undergraduate. If there are to be levies that you have to opt out of, a defensible case can be made for them, provided the process of opting out is easy and is advertised to every member. Does my honourable friend know whether the government proposes to institute mechanisms to make it known to every member how easily they can opt out?
Greg.
My right honourable friend makes an incredibly important point on this, because if you look at the detail of this bill, Madam Deputy Speaker, what is very clear and obvious is that the government are trying to make it as difficult as possible for people to opt out of the trade union political fund. That is the very point of them changing this legislation. And opt-in, I'm going to make a bit of progress and then I will come to the honourable lady. An opt-in is the default under consumer protection law and information law. Combined with the 10-year reminder change, it is highly likely that many trade union members will not be aware that their subscriptions are being used in this way, and that they are eligible to save money on their trade union fees by not being a member of the political fund. Despite all the talk of supporting working people, it is clear that concern simply does not apply when working people's money is being taken to fund the Labour Party and other political causes. We have tabled Amendment 291 because we fundamentally believe that people should consent explicitly what is, in effect, to a subscription trap. Amendment 291 simply maintains the status quo. It is the right thing to do. The Secretary of State for Business and Trade... OK.
Many thanks, and thank you, Madam Deputy Speaker. I draw attention to my register of interest, my membership of Community in Usdaw. Can the honourable gentleman tell us how many times that such a ballot has actually resulted in the closure of a political fund?
The honourable lady is putting a smoke and mirrors argument up here to try and cover the fact that they are changing the status quo of an opt-in system to an opt-out system. To me, it is just straightforward common sense that something like this people would expect to have to opt into, not this particularly egregious case of every 10 years being casually reminded that, well, maybe they could save a bit of money by opting out to a cause that perhaps they don't even agree with in the first place. The Secretary of State for Business and Trade pledged, in fact, to end auto-renewal subscriptions, because when this side were in government, we passed the Digital Markets, Competition and Consumers Bill. This contained two significant proposals on subscription contracts that are notable here. Reminder notices that businesses need to provide notices to consumers to remind them that their subscription contract will renew and that payment will be due unless the consumer cancels. And secondly, to allow consumers to be able to exit a subscription contract in a straightforward, cost-effective and timely way. Businesses will need to ensure that the process for terminating is not unduly onerous and that consumers can signal their intent to end the contract through a single communication. Now, the Labour Party, then in opposition, supported those aims. In fact, the bill did not go far enough for them at the time. During report stage, the honourable member for Pontypridd tabled new clause 29, which the Labour Party voted to add to the bill. This new clause had a two-pronged approach. It required traders to ask consumers whether they wished to opt into subscriptions renewing automatically, either after a period of 6 months and every 6 months thereafter, or if the period between the consumer being charged for the first and second time is longer than 6 months, each time payment is due. The second limb of that new clause that the Labour Party used to support would have required that if the consumer did not opt into the arrangement just described, the trader had to provide a date by which the consumer must notify the trader of the consumer's intention to renew the contract, which must be no earlier than 28 days before the renewal date. If the consumer did not provide the notification, the subscription contract could not renew. So where am I going with this, Madam Deputy Speaker? They're chuntering too early. They're chuntering too early. Because there's a considerable shift in the Labour Party's policy position on subscription traps. The Labour Party seems to believe that consumers should be given every possible opportunity to cancel subscription contracts with businesses, but it should be as hard as possible to cancel a subscription to the Trade Union Political Fund. That is why we've tabled Amendment 292 and new Clause 88, so that members of trade unions receive the same rights that Labour pushed for other individuals with a subscription. Madam Deputy Speaker, moving to New Schedule 2. New Schedule 2 is just another amendment that could be used to give sweeping powers to the trade union paymasters of those on the benches sat opposite me. It will give the Secretary of State powers to reduce the threshold for trade union recognition to as low as just 2% of the workforce. By doing so, trade unions could easily be imposed on workplaces across the country, with small employers being particularly vulnerable. For example, in a workplace of 200 workers, less than five would be required for workplace recognition. Paired with the other measures in this bill, this will strike fear into business owners across Britain, who could now be forced to deal with all-powerful trade unions as part of Labour's return to the 1970s. But the way Labour have gone about this is just another example of the shoddy nature of this bill and Labour's approach to workplace regulations. As the Attorney-General has said, excessive reliance on delegated powers, Henry VIII clauses or skeleton legislation upsets the proper balance between Parliament and the Executive. This not only strikes at the rule of law values, and quoting her, I have already outlined, but also at the cardinal principles of accessibility and legal certainty. So I move on, Madam Deputy Speaker, to talk about facility time through Amendments 293 and 295, which would leave out Clause 54. Facilities provided to trade union officials and learning representatives, and leave out Clause 55, facilities for equality representatives. These amendments will remove those aforementioned clauses and to remove the requirement to provide reasonable time off for facilities time, the removal of the creation of facilities time for equalities representatives, and removes clauses that will reduce transparency requirements over facilities time, respectively. And then Amendment 296, which is together with these to prevent facility time for equality representatives from being provided unless the relevant public sector organisation is meeting its statutory targets for performance. Trade union facility time, Madam Deputy Speaker, already costs the government nearly £100 million a year. Under the last Labour government, the civil service spent 0.26% of its annual pay bill on facility time, compared to 0.04% in the private sector. In the civil service, the average was 0.05% in 2022 to 2023, under the last Conservative government. And Labour councils, Madam Deputy Speaker, are still the worst culprit. The transparency data collected by the government in 22-23 shows that the Mayor of London, Sadiq Khan's Transport for London, has 881 full-time equivalent union officials on the books, costing £8 million a year. Bankrupt Labour-run Birmingham City Council has 30 full-time equivalent union officials on its central books, costing £1.2 million. It's no wonder they went bankrupt. And further, 12 full-time equivalents in its maintained schools, costing £583,000. But Clause 54 and 55 will increase this cost by giving more time off to public sector union officials at the tax taxpayers' expense. That is not right when the Chancellor is asking ministers to make cuts to their departments across the board, meaning that public services will be worse with the taxpayer expected to contribute more. Furthermore, this bill extends that right to equality representatives who will now be allowed paid time off work to carry out activities for the purposes of promoting value of equality in the workplace, arrange learning or training matters relating to equality in the workplace, provide information, advice or support to qualifying members of the trade union in relation to matters relating to equality in the workplace, consult with the employer on matters relating to equality in the workplace, and obtain and analyse information relating to equality in the workplace. All noble goals, but that should not be done at the taxpayer's expense. I make no...
Does the Shadow Minister agree with me that the only jobs that will be created by these bills are those people employed by trades unions?
Yeah. Before Mr Smith returns to respond to that, I must add we've got shy of 40 people hoping to contribute. Just a little notice that we want to get them all in.
I, as ever, take your advice, Madam Deputy Speaker, and will speed up. But we'll first say, the Minister. The Minister urges me to carry on. I, of course, would not ignore your advice. Well, never say never again. Anyway, I make no comment on the value of these activities will add to public sector employers and their productivity. But what I would say is that we have already seen this government happy to hand over large pay increases to trade unions with no guarantee of anything in return. That is why we have tabled Amendments 293, 295 and 296 in an attempt to make sure the taxpayer is getting something out of this latest concession to the trade unions. As briefly as I can, Madam Deputy Speaker, on Amendment 297, trade unions can create significant disruption in the economy, whether stopping work from taking place or preventing people from getting to work or school or to hospital appointments or many other activities. That is why it is important that a fair balance is struck between the ability of trade unions to strike and the public we all serve. Our Amendment 297 will mean that vital public services such as the NHS can better plan and prepare for strikes. It simply seeks to keep the status quo of 2 weeks' notice. Without adequate warning, constituents of members from across the House are more likely to miss hospital appointments, not be able to travel to see loved ones, or get to work, or suffer greater disruption when schools close due to strikes. That is part of the reason why in the consultation on thresholds, 58% of those who responded support, Madam Deputy Speaker, retaining the 14-day period as it currently is, with only 7% preferring a longer period. Two-thirds of respondents wanted the period to stay the same or longer. Labour promised they would work with business on this bill, but their response to the consultation is just another example of them having their fingers in their ears and simply not listening. The reduction to 10 days is against the wishes of business, will do harm to all of our constituents, and that is why we have tabled Amendment 297 to retain the notice period at 14 days. On Amendment 299, very briefly, strikes should only take place when there is a clear mandate for them. But Clause 58 will mean that strikes can happen with low thresholds by removing the 50% turnout requirement and the 40% support requirement. Combined with government amendments to extend the mandate for strikes from 6 months to 12, this bill allows unions to unleash waves of low support rolling strikes. These costs will come on top of the National Insurance Jobs Tax and changes to business rates, mistakes the government are already making and making running a business more difficult, which is why we have tabled Amendment 299 to remove Clause 58. Madam Deputy Speaker, there is much in this bill to talk to. I will not test your patience or the patience of the House further by going into them, but I look forward to a thorough debate, not least from the benches behind me, to further point out why the amendments the government have put down in this bill this afternoon will harm our economy, destroy jobs and just give more power to the trade unions.
Yeah. Point of order.
Mr Mayhew, is it pertinent to this actual debate?
Yes.
Point of order, Jerome Mayhew.
Madam Deputy Speaker, as we all know, members are required to draw attention to any potential conflicts of interest prior to speaking to avoid any impression, amongst other things, of paid advocacy. Given that Clause 52 will lead directly to increased payment of money from unions to Labour members of Parliament, I ask for guidance on the proper declaration of interests. Most members of the party opposite listed to speak this afternoon have received thousands of pounds from the unions. Totted up, I make it £283,974.86. So, Madam Deputy Speaker, in addition to the general reference to their register of interests, in this instance where there is this direct link, should they also set out the actual amount of money that they have received?
There's obviously some further clarity required on this, as it was raised earlier on. It is the responsibility of individual members to ensure that they declare their interest properly. The procedure for raising a complaint of this sort is by writing to the Parliamentary Commissioner for Standards. The guide to the rules sets out the rules relating to the declaration of interest in the debate. This is not otherwise a matter for the Chair. Hopefully that brings some further clarity to that issue. Now, Chair of the Select Committee, Liam Byrne.
Madam Deputy Speaker, thank you very much indeed for calling me. I'll start with my declaration of interest as a former member of the CBI and indeed a current member of the trade union Unison. Let me just try and bring a few points of consensus. I'm old enough to remember, Madam Deputy Speaker, when members opposite, like the former member for Harlow, were writing pamphlets for think tanks like Demos with titles like "Stop the Union Bashing," "Why Conservatives Should Embrace the Trade Union Movement." And of course that was an echo of something Harold Macmillan used to say in the 1950s. In the 1950s, Harold Macmillan famously said, we used to think that we couldn't have a modern industrial society without trade unions. I still think that. So I think we would all benefit from just a little bit of acknowledgement that industrial relations in this country have not been in a good place. In fact, in 2023, there were more days lost to strikes than at any point in the last 30 years. At the back end of 2022, Madam Deputy Speaker, the ONS calculated that 2.5 million days had been lost to strike action. That is not a record that any one of us in this House should be proud of. It is incumbent on all of us to modernise industrial relations in this country so that we are not divided in this way in the workplace. So I welcome the measures in this bill, and I hope that the Minister will actually use the moment, seize the moment, the fact that we have not only got this bill, but also the advent of an industrial strategy that is going to bring together governance arrangements that get businesses and unions around the table to talk about economic growth in our country. That's a big moment. It's a big opportunity. It's a big moment when actually we can bring together our country around a modern industrial strategy. And I hope the Minister, when he has got this bill done and had a little bit of a rest, maybe gone on holiday for a bit, will actually think about how we bring together, how the government will then publish a modern industrial strategy for the future, backed by a restoration of some of the data that we used to have in this country, such as the Workplace Employee Survey, which we used to have until about 2012, until it was stopped. We need to be more thoughtful about harmony in the workplace because it is in the interest of the constituents that we serve. I give way to the honourable member.
I thank the right honourable member for giving way, and he used the term modernising industrial relations, which does sound like a little bit of a euphemism, but to take him at his word on that, is he therefore not surprised that in the pay rises that have come since this government has come in for doctors and for train drivers and a number of other unions, no requirement for increased productivity has been put alongside those pay increases? Surely if we're going to have a modernised industrial relations, it should be combining increased pay that they want, but also the productivity gains that this country needs.
Well, the honourable member no doubt will have heard the remarks made by the Chancellor of the Duchy of the Exchequer at the weekend. And of course, I suspect he will see, like every member of this House will see, some pretty radical steps taken in the Comprehensive Spending Review to improve the efficiency of the civil service, which of course grew very significantly in the years after COVID and now has to be reinvented for new times. So I'm confident that those productivity gains will come. So the second point, Madam Deputy Speaker, that I wanted to make was to draw the House's attention to some of the evidence that we took in the Select Committee and in the report, which I commend to all honourable members, because what struck me in the evidence that we heard from the most productive firms in the country, firms like Jaguar Land Rover, like Rolls-Royce, like British Aerospace. These are world-beating companies. These are some of the most productive companies in our country. And what characterises the workplace arrangements in all of those companies is that they have very long-standing, very robust, very deep partnerships with good trade unions. And those trade unions help make decisions, they help deconflict things, and they help businesses thrive and succeed. And that's why stronger collective rights are important. We also, I'm afraid to say, Madam Deputy Speaker, took evidence from companies where there was not that harmony. Companies like Amazon, a company that has had to call ambulances to its warehouses 1,400 times in just 5 years, where we on the committee received whistleblower evidence from workers who were literally having to urinate into bottles because they did not dare take time out from their tasks to go to the bathroom and back, where we heard all kinds of whistleblower complaints around injuries that were being sustained, where pay is rising much slower than sales. But when we had executives from the company in front of us, they could not or would not tell the committee why strike action had been taken by workers in their firms. I have to say, if a company executive cannot explain to a select committee in this House why so many of its workers are on strike, that is not a story of harmony. That's not a recipe for success. And that's why I think the measures that the Minister has brought forward in this bill to improve the opportunities for trade unions to organise in a way actually that was recommended by the former Honourable Member for Harlow, are a good thing. Now, the Minister has gone some way in recognising recommendations made by our committee, such as improving beyond 24 hours the window in which complaints can be heard, template access agreements, and strengthening the role of CAC in dispute resolution. But there was just one step further that I would suggest, which is the subject of Amendment 282, which is where we suggest that access rights for trade unions do indeed include digital access rights. Because in the modern workplace, and Amazon was a case in point, at the moment there simply isn't an opportunity for workers to get information about the opportunities to join a trade union and make a fair choice one way or the other in the way that there could be in the modern economy. The final point, Madam Deputy Speaker, that I wanted to make was around enforcement. The first Factory Act passed by this House was the Act of 1802, which was the Health and Morals of Apprentices Act. It was celebrated in parliamentary history as an act that failed because there was no enforcement attached to it. Enforcement of this bill is absolutely essential if it is to succeed. But today, labour market enforcement is much too weak. Just 21 employers have been prosecuted for minimum wage enforcement since 2007, despite the fact that we all know in our constituencies there are abuses of this sort taking place. Spending on labour market enforcers has been flat since 2014, and we are well off the ILO target of one labour market inspector for every 10,000 workers. And so new clause 82 in my name requires the Secretary of State to set out a roadmap for reaching that ILO target, for ensuring there is greater use of penalties where appropriate, and for much stronger partnerships between the Home Office and the police and the Fair Work Agency. We cannot have in this country a situation where the best of British firms are being undercut by the worst labour market practice in the country. So, in conclusion, Madam Deputy Speaker, I welcome this bill. I think there are some amendments that have been tabled today which would improve it. But ultimately, we have got to remember that if we want to create a genuinely pro-business, pro-worker economy, then the measures in this bill are long overdue.
Liberal Democrat spokesperson, Daisy Cooper.
Thank you, Madam Deputy Speaker. I rise to speak to parts 4 and 5 of the bill, and specifically new clause 19, which is tabled in the name of my honourable friend, the member for Torbay, and new clauses 110, 111 and 112 tabled in my name. And I'd just like to put on record my thanks to my two Liberal Democrat colleagues, the honourable members for Torbay and Chippenham, for their work on the Bill Committee, alongside many other members of this House. Madam Deputy Speaker, overall, throughout the passage of this bill, we Liberal Democrats have indicated our support for many aspects of the Employment Rights Bill, as was debated yesterday, boosting statutory sick pay, strengthening parental pay and leave, and giving people on zero and low hours contracts more certainty. However, Madam Deputy Speaker, a lot of crucial detail has been left for secondary legislation, for lots of new government amendments and continuing consultations, which make it impossible to explicitly endorse the bill as a whole at this stage. Even with 264 amendments at committee stage and 457 government amendments at report stage, there are still major issues that are yet to be determined, especially in Part 4. Even after all of these amendments, the government says that the government intends to consult further on modernising the trade union landscape following royal assent of the Employment Rights Bill, including on admissibility requirements, a code of practice and secondary legislation. So, Madam Deputy Speaker, it's clear that Part 4 of the bill, which we are debating today, is still far from finalised. We Liberal Democrats believe that employee participation in the workplace is vitally important, but we also believe it should go hand in hand with wider employee ownership. This is so important for diffusing economic power, promoting enterprise, increasing job satisfaction, improving service to customers, and getting long-term economic stability and growth. The government's proposals on trade unions are really aimed at strengthening employee rights in what can often be a combative and confrontational working environment. And we Liberal Democrats see this bill as a missed opportunity to improve employee engagement and ownership that can provide collaborative working environments and long-term growth, whether that's through reforming company purpose rules or putting a duty on employers to encourage employee ownership in large listed companies. However, Madam Deputy Speaker, given what we have before us, there are a few amendments that we have tabled. The first is NC 19, the right to be accompanied. It does what it says on the tin. It would expand the right for staff to be accompanied by a certified companion at disciplinary and grievance hearings. This is long-standing Liberal Democrat policy and I hope is not too controversial, as it simply rectifies an anomaly. At the moment, the current law allows only trade union representatives or colleagues to accompany an employee, and this leaves many other employees without proper support. Some sectors, like the medical professional, already allow accompaniment by non-union companions, yet this is not reflected in law. Our targeted amendment would fix this anomaly, and I urge the government to accept it. New clause 110. This simply requests the government to conduct a review into the impact on small business. Madam Deputy Speaker, throughout the passage of this bill, we have raised concerns about the cumulative impact of all of the government's work in this area and the impact that it will have on small businesses in particular. Just the other day, the Federation of Small Businesses told me that they spend thousands of hours, thousands and thousands of hours, giving advice to small businesses on employment matters. And these new obligations will create a huge amount of extra law for them to understand, to interpret and apply. Small businesses do not have the same resources as big business. They often don't have a legal department, no compliance team, perhaps no HR specialist. But because small businesses are often rooted in their community, they are really conscious of their reputation. They know their employees and they want to get things right. This means it is going to take extra time, effort and cost for them to navigate and comply with this part of the bill. And that's before we get to everything else, Madam Deputy Speaker, that the government is seeking to introduce. Taking together the measures of the employment bill, the national insurance, the business rates changes and everything else, small businesses are telling me that they feel overwhelmed. All this clause does is ask the government to conduct an impact assessment. We know that small businesses are passionate about their employees. Small businesses are often the ones to give people their first job ever. They're often the companies that give people a second chance. They provide part-time, flexible working and opportunities to return to work. So I encourage the government to look at the impact of Part 4 on small businesses. New clause 111, Madam Deputy Speaker, is about introducing legal aid in employment tribunals. Now, when legal aid was first introduced, it was regarded as, or the intention was, for it to become the NHS of the justice system. But we know that today legal aid is far from that. Our amendment would require the Secretary of State to report on options for expanding the right to legal aid in employment tribunals. We already know that many employees cannot afford legal representation, and this creates an imbalance of power when facing well-resourced employers. This amendment simply asks the government to look at the options that might be available in this regard. And new clause 112 is looking at asking for a review of the single enforcement body. Now, we Liberal Democrats positively support the government's efforts to create a single point of contact rather than four. A similar measure was in our manifesto, where we called for a powerful new worker protection enforcement authority. But as a matter of good practice, when putting different organisations together, it is important to make sure that no gaps are created in that protection. So this is not just a formality, but I think an important safeguard to ensure that employment rights enforcement is effective, fair and fit for purpose. In conclusion, Madam Deputy Speaker, there is much in the Employment Bill that we Liberal Democrats welcome, but there are many areas that we simply cannot support because it is not clear yet what the Government's intentions are. We do urge the Government in the strongest possible terms to look at the impact on small business, as this is one area that we are deeply concerned about. Thank you.
Lavery.
Thank you, Madam Deputy Speaker. It's a pleasure to speak in this debate this afternoon and following the honourable member from Maid, Buckinghamshire, the Shadow Minister. I've got to remind him, Madam Deputy Speaker, that trade unionists are the bedrock of our communities. They are the producers of the wealth in this country. They are taxpayers. The ordinary, hard-working people. They shouldn't be basically described as the dirt on the shoes of other people. The Shadow Minister could hardly hide his disdain for ordinary working people. He couldn't hold himself back in his contribution and basically opposing everything within this bill. I want to refer to my declaration of interest as a proud trade union member of the National Union of Mine Workers, of Unite the Union, and an honorary member of the Prison Officers Association, and also chair of the trade union group of Labour MPs. But it is, Madam Deputy Speaker, an absolute pleasure to speak today on a piece of legislation which turns the tide on decades of anti-trade union laws. Laws which have restricted the power of workers and seen the wealth of those at the top grow exponentially. Personally, Madam Deputy Speaker, it's fitting to see this bill in front of the Commons this week because last Wednesday marked the 40 years since myself, my father who sadly passed on, my brothers and thousands of my colleagues marched back to work at the end of the miners' strike. And although bruised and battered, the fact that I'm still here today speaking on this bill proves that whilst the party of vulture capital may have won a victory in 1985, you didn't win the war. But whilst this is a good bill, I think it could have been a lot better, and through time and further discussion and further legislation, it'll prove to be a great bill. Madam Deputy Speaker, I draw the attention of the House to the amendments submitted in my name that I think will positively strengthen and enhance this bill. It's on these amendments that I intend to focus the remainder of my contribution. Workers in the UK have never, ever had the right to strike. However, since 1906, the unions have had protection against common law liability, subject to statutory conditions being met. New Clause 108 would establish a positive right to strike, bringing the UK in line with most of the democratic world. It would also remove provisions that make strike action unlawful if it turns out, retrospectively, that the action the worker took was unofficial. And I think this is important because a worker currently has to take in good faith that the union has managed to navigate the bureaucracy of taking action and that unscrupulous bosses cannot summarily dismiss if they have not. New Clause 109 is wide-ranging. The UK's ban on secondary action is almost unique in the world. Condemned on every occasion, the ILO have considered the position since 1989. When P&O Ferries flouted its legal obligations by not consulting over mass dismissals and by dismissing unfairly, the unions were unable to react by calling on dock workers and lorry drivers and other industries on the the dockside, to boycott the vessels in dispute. That was outrageous. We need to bring back solidarity action. I want to support people in industrial disputes. And section on new clause 109 tackles that. This clause would put this right by ending the ban on secondary action, which that would have constituted. I would basically remove it. The clause 109 would remove the need to provide a ballot paper to the employer and remove an obligation on unions in long-run disputes to rerun the ballot every 6 months. It will enable industrial action to achieve recognition for collective bargaining. Amendments 347 to 348 would change the requirements for notification about the results of a union ballot, meaning they could be displayed online with ease of access to the public. Amendments 345 to 346 would remove the restriction confining pickets to their workplace. The reason secondary picketing was banned in the first place was because it was a tool that benefited workers and advanced their cause. Solidarity action should be an important part of seeking resolution to disputes. You know, Madam Deputy Speaker, this brings measures that aim to end discrimination and place equality at the heart of the workplace. It gives key workers in social care and school support more say on pay and conditions through their unions. It brings measures to tackle exploitative zero-hour contracts. It gives protection against unfair dismissal from day one and extends sick pay rights. It repeals minimum service level laws in the majority of the Reactionary Trade Union Act of 2016. Greater rights for workers to organise collectively through their trade unions, and reduces bureaucracy on trade unions during industrial action processes. Finally, Madam Deputy Speaker, the howls of derision from those opposite show that the Labour government are doing the right thing. This is a good bill that should mark the start of a process. I hope the front bench and my honourable friend, the member for Ellesmere Port and Bromborough, who's done a fantastic job. I hope he understands and appreciates the fact that we all are just trying to strengthen this bill through the amendments which we are putting forward. But, Mr. Deputy Speaker, whilst we expect the howls from the Conservatives, whilst we accept the howls of derision from the Conservatives, it's worth reminding this House that, indeed, reminding the country that the turquoise Trumpian Tories in reform have also opposed this bill at every stage, at every step of the way. Perhaps it's because as a company, and that's what they want to ensure that workers, for example, the member from Great Yarmouth, for example, is limited in how he addresses workplace bullying from the owner. Or perhaps it's because whilst they masquerade as a party for the ordinary men and women of this country, you know, in reality they're simply a Margaret Thatcher tribute act with a sprinkle of bigotry determined to advance her destructive agenda at all costs, regardless of its impact on working people across this country.
Right, we've got over 30 members wishing to contribute. I don't want to set a time limit, but if people could police themselves and keep their speeches to shy of 8 minutes, everybody will definitely get in. And Charlie Dewhirst, your turn next.
Thank you, Madam Deputy Speaker. I wish to develop some of the very detailed and eloquent arguments put forward by my honourable friend, the member for Mid-Buckinghamshire, and speak to those amendments, particularly in relation to Part 4 of the bill and the trade union movement. And before he leaves, I would like to thank the right honourable member, the member for Birmingham, Hodge Hill and Solihull North, for his very measured comments. I enjoyed his referral back to the 1950s and industrial relations then. We have moved on a little since then, I would point out, and I will develop some of that argument going forward. And I think he also slightly simplified the opposition's position here. We are not here to bash the unions. We support a progressive, modern trade union movement where the balance is struck correctly between employer and employees. Unions should not and do not run businesses, but they are an important part of our industrial relations landscape. Now, there can be little doubt, Madam Deputy Speaker, that this is a bill, unfortunately, drafted by the few to the detriment, sadly, of the many. And the number of provisions which will largely abolish the Trade Union Act 2016 threaten to drag the country back to the dark days of the 1970s. I think in the very enjoyable speech we've just had from the Honourable Member for Blyth at Ashington perhaps rather illustrates that return to the 70s, and I'm pleased to see a number of his friends from the rebellious left on the benches today, and I look forward to hearing their comments in due course. But the Trade Union Act of 2016 was brought in by the last Conservative government to reflect the modern British economy and workplace. It moved the trade union movement into the 21st century and ensured hard-working people are not disrupted by little supported strike action. Because the world... I'd be delighted to.
We have been blighted by, I think it's approximately 7 years of strike action by Northern. Does he agree with me that, in fact, the key to modern industrial relations is to have good industrial relations, not to pull apart bills that make things better?
Yes, well, I mean, I think the best solution to that would be a more proper privatisation of railways, so that nationalised services like Northern, which are constantly on strike. I would use the example in this case of Hull Trains, which serves a lot of constituents in my area, which is very, very rarely, if at all, on strike, as an excellent private open access firm. And actually, those of the rails franchises which have been nationalised have far greater problem with strike action than those that are not. Now, I wish to go back to the 70s again briefly, to the height of the trade union movement, which numbers peaked in 1979 at around 14 million. Since then, they have declined considerably, down to around 6 million. The majority of those are within the public sector, and for good reason often, that members people are members of a union in the public sector. But it does mean the landscape has changed. We've moved from a society and an economy of heavy industry and of large manufacturing, of towns that may have been built on one or two industries or one or two factories, where everybody in that area was employed largely directly or indirectly in those places. And actually, that was where the trade union movement was required, where it was strong, where it was needed. The modern workplace is very, very different. We are now largely a services-based economy. The relationship between employer and employee is much more modern, much more flexible. And therefore, the need for that traditional movement, which we've heard, and a return to secondary action and flying pickets, etc., clearly there is no place for that at all in the UK. Now, because we must remember... Sorry.
I'm very grateful for the member giving way. The gentleman opposite, I understood him to suggest that we should have a return to secondary action. What's your view? What's his view?
I don't want to speak on behalf of the honourable member, but I think he's made his comments. You've made your comments very clear, and I'm sure we'll be hearing more in that tone as we go through the afternoon, because it's really important that this bill does not take us back to a place where growth is stifled. The government is talking about the importance of growth, but you take this bill alongside the budget and we will have a very, very severe problem going forward, because there is very little point of having extra trade union representation if unemployment is going through the roof. Those who are unemployed will not be represented. My big fear here is that this overall is an act of economic sabotage. It's protecting the dinosaurs from extinction. It damages the UK economy, and it only ensures the trade union donations continue to flow into the Labour Party.
Katrina Murray.
Madam Deputy Speaker, and before I start my contribution, my membership of Unison and the membership of the National Executive of Unison prior to election is well documented. I draw the House's attention to my register of interest, but what people on this side of the House probably don't know is that I am also an associate member of the CIPD, the professional body for the people profession, and have spent over 20 years as a manager and as an employer. I have therefore spent most of my career working with people, managing people and employing people. I have ensured that staffing levels are maintained on hours that people are contracted to work, are able to work. I've managed their flexibility without having to resort to bank or agency staff every week. But as a trade union rep, I've prepared for, I've worked on consultative ballots, statutory industrial action ballots, and political fund ballots. I've worked done the hard yards. I've walked the wards at 3 o'clock in the morning to speak to the night shift. I've gone out to remote workplaces to engage with people. But I've also met and agreed with management of what essential levels of service are. I pay tribute to all of those who have worked on this bill to get it to the place that it is today, and I welcome it coming back to the House. I believe in fair work, where there is a relationship between the employer and the worker which is based on equality. A fair day's work for a fair day's pay. The right of an individual to withdraw that labour should they collectively vote to withdraw the labour. We discussed yesterday what healthy employment relationships look like, and it's about more than just pay. It's about how people are treated at their work. It's about ensuring that people have a guarantee that they don't only have a job, but they have guarantees hours if that's what they want, and that work pays. If someone wants to work full-time, they should not have to work 2 or maybe 3 contracts with the same employer to make up those hours, to work the same excess hours every week for months and months until they want to take an annual leave day, when they then lose entitlement to that. Today's amendments focus on the 2 main aspects of the bill: the rights of trade unions to organise in the way that we recognise in the 21st century, and how this vital piece of legislation is enforced. The world of work, as we have been reminded, has changed fundamentally in the last 20 years, and so has the world of trade unions has done so also. I listened very carefully to the member from St Albans, and with great respect of her view of the combative and adversarial nature of trade unions. That's not the world that I recognise.
Remember for addressing some of my concerns, and I look forward to hearing what she's saying. Just to be really clear, I was talking about what can be a combative working environment between employees and employers, and I was saying there was a missed opportunity to create more collaborative environments. So I wasn't accusing the trade unions necessarily, but there can be working environments that can be combative.
I thank you very much for your intervention. My experience has been working within the partnership arrangement over the past 20 years, where management and staff have worked, and staff-side trade unions as the agreed body and recognised body for those staff within the NHS, is to be naturally to sit down together and say, these are our issues, how do we resolve them? It is an awful lot more financially advantageous that we don't actually end up in a situation where it does get to that adversarial nature. What I want... Electronic balloting has long become common practice, but not for statutory trade union ballots. It's not just the public vote of Strictly Come Dancing or I'm a Celebrity, get me out of here, but also I noticed that the Conservative leadership election in 2024 made a great use of electronic balloting.
That was terrible reality.
However, it's absolutely time for trade union ballots to be brought into line with where society is at. So I welcome the measures within the bill to widen the measures of voting in industrial action ballots. The ultimate... While we're on the subject of balloting, I'm also in support of the extension of the period of time before a reballot takes place to extend the mandate for strike action. The ultimate aim of any form of industrial action is it should be resolved by all of the parties involved, ideally before any action is actually taken, without labour is withdrawn, before individuals lose their money, and before publics are affected. The role of government in this should be to ensure that intransigent parties actually get round the table and talk to resolve those issues. Yet, as the members opposite reminded us, When faced with that opportunity, they did exactly the opposite. They introduced the Strikes Minimum Service Level Act 2023, a piece of legislation which was simply so useless that it stopped precisely 0 strikes. It was used precisely 0 times and is rightly being repealed as part of this this legislation. Because what's not recognised by the members opposite is that trade unions and trade union members don't take action lightly. I do wonder what the Shadow Minister was thinking, because he's obviously never talked to trade union members. Sorry. It's more, people know their rights. They know to belong to things. They want to be involved in that. People collectively make that decision, but they individually make decisions about their subscriptions. And by golly, they know, because they've told me. This hasn't been brought in kicking and screaming. Most businesses who work with people well know exactly what's going on. And in the interest of time, I completely endorse this bill and every aspect of its enforcement. Everybody knows somebody who's being exploited at work. This bill goes back to stop it, to prevent that happening. It's time to rebalance the employment relationship.
Ms Murray, you used the term you earlier on. Please be seated. Please be seated. If it makes it easier, you can continue the debate focused on the chair. That way you won't make that mistake. But thanking me gets very complicated for Hansard, so best not to do that and just focus on the chair, and that will help. I need to make a correction. I should draw members' attention to a printing error in Government New Clause 52, as it appears in the printed version of today's amendment paper. The closing words at the end of subsection 1 should read, "The Secretary of State may withdraw it by giving a notice of withdrawal to the person." A corrected version of the amendment paper is available online. I now come to Jerome Mayhew.
Thank you very much, Madam Deputy Speaker. This is a chaotic mess of a bill, cobbled together in 100 days in order to satisfy a press release. And then we have this sort of unedifying spectacle of an amendment list 274 pages long, Madam Deputy Speaker, trying to correct the many, many mistakes that they already made. But the main thing I want to address in my short speech today, Madam Deputy Speaker, is this idea that Labour is beholden to the unions. It's often suggested, and let's just look at the facts, because we need to put this to bed. Between 2019 and 2024, Labour only received £31,314,589 from the unions, and now in this Parliament, more than 200 Labour MPs have been paid directly by the unions. If you look at the ministers for the Department of Business and Trade, they have collectively received about £120,000 from unions. So what are the unions paying for, Madam Deputy Speaker? Whatever it is, they've been handsomely repaid in the drafting of this bill. Perhaps to make it easier for the members opposite, and they're all here to hear my point of order, perhaps they could just put their hands up if they have not received any cash from the unions. Oh dear, oh dear.
All of them, every single one.
So let's turn, Madam Deputy Speaker, to Clause 52. This suggests that we should have a requirement to contribute to political funds under joining the unions. It changes the rules on how union members should donate, how they should contribute political funds for the Labour Party. If you look at Clause 52.2, it changes from an opt-in to an opt-out. It begs the question, Madam Speaker, why do we need this clause? What is the problem that the Labour Party is trying to fix? Is £31 million just not enough? Yes. What this clause encourages, is that union members, when they're signing up, their unions will take advantage of their distraction that they're not focused on this, and they will fall into what is effectively a subscription trap. Now, in other circumstances, the party opposite don't think that subscription traps are a very good idea. In fact, the government sent out a press release on the 18th of November of last year entitled "New Measures Unveiled to Crack Down on Subscription Traps." That sounds good so far. It says, consultation launched on measures to crack down on subscription traps and better protect shoppers. Unwanted subscriptions cost families £14 per month per subscription and £1.6 billion a year in total. New proposals to crack down on subscription traps have been unveiled today. Then it goes on. Subscription traps are instances where consumers are frequently misled into signing up for a subscription. It comes as new figures reveal consumers are spending billions of pounds each year on unwanted subscriptions due to unclear terms and conditions and complicated cancellation routes. And then, I will in a moment, I'll just finish this point. And then the Business Secretary, the Right Honourable Member for Stalybridge and Hyde, said this, and I quote, "Our mission is to put more money back into people's pockets and improve living standards across this country. Tackling subscription traps that rip people's earnings away is an important part of that." This clause flies in the face of that press release. I will give way.
Does the honourable gentleman agree with me that there is a massive difference between major corporations which want to take money out of people's bank accounts every month and trade unions who want to represent people as effectively as possible in the workplace?
No, I do not accept that difference. Where you're taking advantage of people's inattention, which this clause expressly sets out, then you are taking advantage of people for financial gain. The difference is the people who gain in this instance are the members opposite. Yes. And that begs the question why it is they have drafted this and why, if shamingly, I will in a moment, why shamingly they may yet vote for it later on this evening. So here we have it, Madam Deputy Speaker. We've got a clause where there is a direct financial interest to the members opposite. We've had 2 speakers so far, both of whom have received very significant sums from the unions, which they didn't directly refer to. The first was the Honourable Member for Blyth and Ashington. He has received £20,000, according to his register of interest, from the unions. The second is the Honourable Member for Cumbernauld and Kirkintilloch, who has received £14,000 directly from the unions. This is germane to the debate that we are having right now. This is germane to the debate that we're having right now. I give way.
To him for giving way. As has been said already in this debate, trade union donations have been declared. Donations from employers that have a direct private interest in particular sectors that we have debated in this place have not. If any of his colleagues on his benches have not drawn attention to such an interest, will he encourage them to do so, and will he agree with us on this side that they were wrong to not make such declaration?
There were 2 points of order on declarations earlier, and I think I made the status quite clear. And just to let Mr Mayhew know, if you are referring to members directly and it is any form of criticism, you are meant to give them prior warning. So just be mindful of what comes next in your speech.
The Honourable Member's intervention is classic distraction technique. This is a bill that's addressing the unions. It's union membership, and this is a clause that directly moves money from unsuspecting union joiners directly to the Labour Party. There is no other explanation. There is no other explanation for this bill. I will give way to the Honourable Lady, and then
I thank him for giving way. Thank you, Madam Deputy Speaker. The Honourable Member is working incredibly hard to try and make a case for vested interests in this bill. Vested interests, in fact, which are for the working people of this country. But nevertheless, I appreciate his efforts. He certainly has earned his afternoon snack today. However, given it precedes my time in this chamber, I wonder whether colleagues could help me as to whether he was as vociferous during the pandemic, a time of national crisis, where close relationships with senior government figures ensured contracts that produced no PPE when the country was in such desperate need.
Follow that. So I'm just going to have to move on. I will give way.
The member opposite has just made a point that suggested that working people are not impacted by the behaviours of trade unions. So does my honourable friend agree that it's working people of this country that are hammered the most when their paymasters, the trade unions, go on strike?
Yeah. I completely agree with my honourable friend. I can't add any more to it. I think he's hit the nail on the head. So, Madam Deputy Speaker, I support Amendment 291 in the opposition's name, which removes Clause 52 because it's a circular bill at the moment. It's a circular bill of self-interest. You get money from the unions, the bill then increases union powers, and that clause increases money from the unions. This is brazen, it's shaming, and it should be removed.
Johanna Baxter.
Madam Deputy Speaker, I'd like to start by drawing members' attention to my register of interest and my proud trade union membership of the Communication Workers Union and the GMB. For too long, working families in my constituency of Paisley and Renfrewshire South have been let down by outdated employment laws, laws unfit for a modern economy, leaving too many workers trapped in insecure, low-paid jobs. And when the party opposite crashed the economy, who was it that bore the brunt? It wasn't them. It was the people in insecure, low-paid roles who were left to bear the brunt for their economic incompetence. Everyone watching this debate today will remember on the previous government's watch the dread of opening their bills, seeing the mortgage statements and seeing just how much the costs had skyrocketed. They'll remember standing at the supermarket checkout, forced to put essentials back on the shelves because it cost much more than it did the week before. Some parents will remember sitting at the dinner table, watching their children eat, whilst they themselves went without. For too long, too many people in our communities have gone to work not to build a better future, but simply to scrape by. They have worked very hard for the poverty they then experienced. As a former trade union negotiator, I spent more than 20 years of my working life standing up for those people in low-paid jobs. As a former head of local government for Unison in Scotland, I was proud to represent the bin collectors, the carers, the school support workers, all of whom are the bedrock and backbone of our local communities and upon whom we relied so much during the COVID pandemic. When their bills went up, they turned to their trade unions, asking us to negotiate for nothing more than a fair day's wage for a fair day's work. Yet, under laws introduced by the previous government, fighting for them too often felt like fighting with one arm tied behind our back. Within a legal framework which provided laws that allowed bad businesses to ignore trade unions and the voice of workers, laws that allowed businesses to flood a bargaining group to prevent trade union recognition and weaken workers' voices, and laws that allowed employers the power to impose minimum service levels, was an attack on workers' rights that did nothing to fix the root causes of our struggling public services. Let me be clear, Madam Deputy Speaker, we on this side of the House have no problem with businesses. The problem is that the last government allowed exploitation to thrive. Most businesses want to do right by their workers. They know that fair pay and good conditions lead to happier workers and a more productive economy. They know that treating workers fairly isn't a burden, it's a benefit. And that's why this bill is so important. It fixes these issues, expands statutory sick pay to help keep people improve their health and well-being and get back to work. It improves industrial relations and will give stronger protections for workers with regards to their holiday pay. It introduces a new fair work agency to enforce those new rights because, frankly, there is no point in having those rights unless you can enforce them. What the party opposite just don't get is that to be pro-worker is to be pro-business and pro-growth. When they introduced burdensome red tape on trade unions, they introduced burdensome red tape on businesses and their ability to engage in the bargaining and negotiation process that settles disputes quickly. Negotiations with trade unions means fewer disputes, fewer days lost to industrial action and greater economic stability. At the last general election, this Labour government pledged the biggest upgrade to workers' rights in a generation.
We did.
Restoring dignity in work, putting more money into families' pockets. Today we take another step forward in delivering that promise. And I do want us to be more ambitious. Because we are always ambitious on this side of the House. So I do want to particularly draw my right honourable friend's attention to the potential issue in the bill with regards to the lower earnings limit for statutory sick pay, and hope that that can be resolved when the bill goes to the other place. I want to just finish, Madam Deputy Speaker, on a quote from Paisley's own Robert Tannahill, who said, "Through summer and winter so dreary, I cheerily toiled on the farm. Never once dreamed growing weary, for love gave my labour its charm." Good work is good for people. It provides dignity. Work should provide security, not uncertainty. It should be a source of pride, not precarity. It should be a means of building a good life, not just allowing people to scrape by. That's what this bill stands for. That's what this Labour government stands for, will fight for, and I'm proud to support it.
Thank you, Madam Deputy Speaker. And I'd like to just address the point that the Honourable Lady just made about being pro-worker is pro-business. We on this side of the House do believe being pro-worker is pro-business. The only problem is that this legislation that's been put forward is not pro-worker, it is not pro-business, it will drive up unemployment, it will drive up the regulation on businesses, and therefore the workers that she purports to represent and support will be exactly the people who will suffer at the hands of this legislation. So we on this side of the House absolutely get that. We do. I'm going to talk in favour of the clauses around the political fund, new clause 88 and 291, but also for 299, and refer to some of the points around access to the workplace. And I refer members to my register of interest, not least because I worked in a family business, in a small business before, and I still retain an interest in that family business. But and I was previous to being elected as well, I was also president of the Chamber of Commerce, which represented thousands of, in Greater Birmingham, thousands of small businesses, one of the largest and oldest chambers of commerce in the country and in the world. But Madam Deputy Speaker, let's be in no doubt, this is a terrible piece of legislation. It is a love letter from this Labour government to trade unions, and it will lead to a trail of socialist carnage and destruction which will leave the country reeling for many, many years to come. It harms business. It undermines employment. It will drive up unemployment, and it will do nothing to increase growth or investment in the United Kingdom, the very purported aims of this government. In fact, the government's own original impact assessment, when this bill was first introduced, talked about there being a cost to business of about £4.5 billion, almost reaching £5 billion. But we've yet to see what the impact of these new amendments, this further move to a more socialist version of this bill, what will be the cost to businesses. And look, there was much made of the honourable member, who's a friend of mine, the member for Birmingham, Hodge and Solihull North, and a neighbour of mine, who's talked about the modern workplace. I agree, the workplace has changed from the 1950s and even the 1970s, but this bill will take the workplace back to the 1970s, because what it fails to do is achieve a balance between working people and businesses, and the relationship between trade unions and businesses. In fact, it unfairly it goes way down the line in favouring trade unions, and it actually makes it much harder for people to run businesses. And when I was president of the Chamber of Commerce, I was perfectly fine with trade unions and having good relationships, because I had friends who joined trade unions even though they weren't in unionised workplace. I encouraged it. It was, they needed representation. I thought it was a good thing to do. So I have no problem in the modern workplace to have trade union relationships, but there has to be a balance achieved. And a comment was made earlier about economic units. The economic units are the businesses that create economic growth in the economy. And of course, their workers are really important. My employees were really important to me because my business could not run without them. But the majority of business owners in this country recognise that, and what we recognise on this side of the house, that those people who run businesses, those individuals who work in those businesses, those employees is a symbiotic relationship. Those individuals are drivers of economic change. They're innovators who come up with the ideas. They're the risk takers who then turn a profit which then pays the taxes which serves our public services. And unfortunately, this bill does not recognise any of that. In fact, businesses are absolutely anxious and worried about what this bill is introducing. Someone just, Madam Deputy, shouted, no, they're not. They absolutely are. And a Deputy Prime Minister, when she was challenged on naming a business that supported this bill, could not do so. I'm sure the Honourable Member will have an opportunity to speak on this in his own way. I will do.
I thank my honourable friend for giving way. Does he agree with me that this bill is also badly drafted? Even if you supported the content, it's a badly drafted bill that was brought far too quickly before this House. A huge bill of that nature should have had time to... And it's hardly surprising the government's tabling so many amendments itself, because it's still writing it.
Yeah. Well, I couldn't have made the point better myself, actually. The level of amendments and the cost that is being placed and the regulatory burden that is being placed on businesses, large, medium and small, has worried many, many businesses, not just in my constituency, but across the country. And this business will do immense harm, and it will take a long time to fix the mess that is being created.
I thank my honourable friend for giving way. There are 24 people sitting on the government benches. Would he like to issue an open invitation to any one of those 24 that if they can name a single small business that has been in touch with them to say that they support this legislation, that you will welcome it?
I'm more than happy to extend the invitation, although Madam Deputy Speaker may get annoyed with me if I take 24 interventions.
You won't get one.
Although I don't see anyone jumping, so we'll take that as it is. There is also anxiety about the clauses around access to the workplace. And now the government has gone further to talk about digital access. Of course, for small businesses, this is a huge burden that is being placed upon them. And to willfully and blindly ignore those concerns, I think is really, really shameful. And I think there's a lot of questions that members opposite will have to answer to businesses in their own communities. Those same businesses that will be contributing to the Treasury coffers, that will be paying for the public services, the members opposite will be championing. This is going to be really, really important. And the burden, of course, will go up. And time after time, Madam Deputy Speaker, the party opposite, before the election, after the election, during the passing of legislation, said they were listening to businesses. Well, clearly that isn't the case, and businesses continue to feel like they've been led up the garden path by this damaging Labour government. I'll take an intervention.
Thank you to the honourable member for giving way. I think just to clarify the point about listening to businesses, I think we have listened to business, and Frank from the Chartered Management Institute has gone on record saying that the Employment Rights Bill represents a significant step forward in improving the conditions of the UK workforce.
She speaks to the Deputy Prime Minister, who failed to name a single business when she was challenged to do so. And I'll make in the short time that I've got left now, I'll make a couple of quick points. The members opposite keep saying that this is going to lead to fewer strikes. It's not going to lead to fewer strikes. It makes it easier to strike. In fact, the Transport Secretary today said that strikes in her portfolio will be necessary. This is going to make it easier. It is not going to make it harder. And what it really means is, Madam Deputy Speaker, what it really means is, I can see their exercise, and I'm sure they'll get a chance to comment. That what it really means is that that this country is now at risk of being turned into a 1970s style striking country. And this bill should be a wake-up call for all of those working people that will be undermined, and all those businesses that will be undermined, because it will only be the Conservatives, as we've heard from across the House, only the Conservatives who will stand up for businesses. And I'll finish on this point, because I can see I have questions for all the members opposite, because when people ask what does this Labour government stand for, and it undermines businesses, it undermines working people, I think that is a legitimate question. I fail to see now, other than trade unions, who is it that the Labour Party now stands for? And when people ask us what we stand for as Conservatives, as opposed to the Labour government, well, I think Margaret Thatcher had a very good answer to this. So she said, the Labour Party, because the member before me quoted, I thought I should do a quote as well. The Labour Party believes in turning workers against owners. We believe in turning workers into owners.
Antonio Vance.
Thank you, Madam Deputy Speaker, and I proudly draw attention to my membership of Unite the Union and my declaration in the Register of Members' Interests. Thanks to my friends at the GMB and at ASLEF for their support of my election campaign. I am in this place to stand up for working people, and that is what I will do. The best protection anyone can have at work is the support of their workmates, organised together in a union, bargaining with management, sitting down as equals at the table, making sure business grows and thrives and everyone takes home a fair wage. This bill and the government's amendments will make it easier for working people to choose their union, be represented by their union and get all the benefits of being in a recognised union. An economy where better terms and conditions at work go hand in hand with the sort of growth we need. And let's be clear, this bill supports growth. It could add £13 billion to the economy through improvements to employee well-being, reduced stress, improved national minimum wage compliance, reduced workplace conflict and increased labour market participation, the type of growth that we want. Turning to the amendment, I'll happily give way.
Member for giving way. I invite her to acknowledge the £5 billion cost to businesses that the government's own analysis says will be caused by this bill. I invite her to comment on that.
I thank the honourable member for his intervention. I do indeed acknowledge that, every single pound of which will go into the pocket of a working person in improved rights and higher wages, alongside £13 billion of increased productivity, reduced stress, better employee well-being and reduced conflict in the workplace. Turning now to the amendments, let us start with access to workplaces. This is the key to getting more people into unions. If workers get to meet unions in their workplaces, and I strongly welcome the provisions to give unions the right to access workplaces for meeting, representing, organising, recruiting and for collective bargaining. I'm glad the government amended these rules to make it clear that it's digital access as well as physical. I'm glad to see the CAC oversight too, and for penalties when employers don't comply, as they sometimes do. Now, of course, once a union has established membership in a workplace, they will want to seek recognition. Now, most employers don't have to be forced to recognise a union. It's just what you do as a responsible employer. But where employers refuse, statutory recognition can be triggered. But this process, until now, has been absolutely mad, totally dysfunctional, and the cards are stacked against the working people and their union at every single turn. Now, the worst example of this in recent years is at BHX4 in Coventry, where a company dedicated to keeping unions out of their warehouses brought their US-style industrial relations to the UK, took on their own workers who wanted no more and no less than for management to have to sit down and negotiate with their union, the GMB. Now, Amazon is a £27 billion company in the UK, yet its sales are growing 3 times higher than its frontline workers' wages, and it has had 1,400 ambulance call-outs in just 5 years. BHX4 in Coventry is not a safe workplace. Fulfilment centre workers getting injured, being asked to pick up too much, to load from the back of vehicles on their own, to lift heavy weights above their head. And those workers at that Amazon plant were forced to take 37 days of industrial action over poverty pay. Something that at the Select Committee, their badly briefed, evasive executives could not bring themselves to say or acknowledge. Recognising GMB is a modest request. 1,000 companies would have accepted without question, but not Amazon. At the Select Committee, the GMB organiser Amanda Gearing told us that Amazon flooded the bargaining unit, 1,400 workers when GMB first sought statutory recognition. Strangely, in just 27 days after that application went in, it went up to 2,749. Amanda told us about how Amazon delayed the access agreement 52 days to agree access to that workplace, a chance for the company to swamp the workers with anti-union propaganda. All the screens in the warehouse, anti-union. On the app used for work allocation, anti-union. Threatening to close the site if workers unionised. When the access scheme was finally agreed, the GMB got a tiny number of screens, one 45-minute session with each worker. Amazon had 5 one-hour sessions and screens everywhere. They induced GMB members to leave the union and in every way impeded access. Now, I want to pay tribute here in this place to the GMB leaders at Amazon in Coventry, Kefarina Floresca, Garfield Hilton, Paramanathan Pradeep, Mohammed Nur Mohammed, heroes, all of them, standing up to huge intimidation and under huge pressure they ran a brilliant campaign. But the deck was stacked against them. I will do in just a moment. But the deck was stacked against them and they lost the ballot by a heartbreaking 29 votes. Now, their GS, their General Secretary, is my friend, Gary Smith, and he is clear. If this legislation that we're debating today had been in place, then GMB members and Amazon would have won their fight. I'll give way to my honourable friend.
I thank the honourable lady for giving way, and she's a fearsome campaigner on the Business and Trade Committee. She talks there about intimidation. She paints a lovely picture of unions working actively for their workers, but how can we square that with the version of intimidation which the honourable member for Blyth and Ashington seemed to be referring to when he wanted the return of flying pickets?
Yeah. Before the member responds, no doubt she'll be realising she's close to her 8 minutes. I know she wants to speak a little while, but not too long.
Thank you, Madam Deputy Speaker, and I thank my fellow member of the Business and Trade Select Committee for his intervention. As he will have seen from the order paper, the Government is not proposing the return of secondary picketing. New Schedule Number 2 will give unions greater protection from unfair practices during a recognition process and make winning it more likely. Now, I wish ministers had gone the whole hog and deleted the 3-year lockout, and perhaps there'll be an opportunity to take that forward. In conclusion, I think as a whole, this package of modern industrial relations will lead to more sitting round tables, sorting out issues, fewer picket lines, fewer strikes, more productive relationships, more long-termism across our industrial base, better jobs, higher wages, higher skills, higher productivity. And that is why the changes to this bill to collective rights as well as individual rights are so crucial and so opposed by the Tories and the absent Reform Party. This is the type of growth that my party stands for, Madam Deputy Speaker, the type of growth where proceeds are shared by all. It's time to make work pay.
Yeah. Lincoln Job.
Yeah. Thank you, Madam Deputy Speaker, and it's a great pleasure to follow the honourable member for Tipton. She's such a compelling advocate that I'm tempted to go on strike myself. I do sense a certain amount of antipathy between the two sides of the House, and I'm going to come on to make a very fair point in support of Amendment 292. So I want to prepare the ground by doing two things. Firstly is by trying to convince the members opposite that I am, they missed an opportunity because I am actually at heart a rabble-rousing potential motivator of people. And I say that because I think it was about 3 Christmases ago, the ambulance drivers went on strike. And it really irked me that the soldiers who were going to stand in for them at no notice were going to have their Christmas ruined. Yeah. And so I started a campaign in order to try to get them an additional 20 quid for every day that they were standing in for the ambulance drivers. And this was, the Chancellor would have loved this, net positive to the Treasury, because of course the departments who employ the ambulance drivers and the arm's length bodies don't pay on strike days. The pay differential between them and the 20 quid bung to the soldiers meant that actually the government still saved money. I managed to get a letter into the paper. I managed to get the Sun on board, did a bit of television, and it was just fortuitous that the Secretary of State, I will give way.
Not ashamed of his government's record that hard-working ambulance drivers felt they had to go on strike?
I think she slightly missed the point of what I was saying, and I was reading the body language of the members opposite. I think they all wanted to hear how this story ended up, because it did happen to help that the Secretary of State for Defence was a friend of mine who I served with in the Scots Guards. That did help, but we did get this 20 quid bung for all the service personnel who stood in, regardless of the fact, interestingly, that all the generals and the air marshals and the admirals were against it, as were all the officials. So there you go. I am very much have the same values at my heart. And I would also, in order to win over the other side of the House to the very fair point that I'm going to come on to make, I'd like to pay tribute in particular to something that the member for Birmingham Hodge Hill said in his remarks earlier on. And it was in respect of union membership. And he said, I want people to make a fair choice, one way or the other. A fair choice, one way or the other. And also, I noted that the member for Cumbernauld and Kirkintilloch also referred to fair work. And so I just want to come back to that theme of fairness in addressing Amendment 292. This bill is, to put it politely, something of a cat's cradle of clauses, so I will briefly remind the House that the bill seeks to place on employers an obligation to give the worker a written statement that the worker has the right to join a union, and if they do join, to contribute to the political fund. Amendment 292 would simply inject a bit of balance into that legislation by requiring trade unions to notify their members annually that they have a right to opt out of the political fund and to obtain an annual opt-in from their members. This all puts me in mind of 1988, when Mrs. Thatcher was just about to go and visit Poland. And she was asked in this place at the Prime Minister's questions in November, just prior to her going. A member of the opposition stood up and said, when the Prime Minister is over speaking to Lech Walesa, will she be raising with him the right to join a trade union? There may be some members here who were there. I'm not going to be so ingallant as to ask, but there was a roar that went up from the Labour benches, and the redoubtable Mrs. Thatcher said, I will be raising with the Poles the right to join a trade union, but I will also be raising with them the right not to be a member too. The bill seeks to whack the pendulum pretty hard in favour of union power. Our amendment would seek to bring the bill back into balance somewhat. We all know someone, after all, who has fallen prey to one of those charity muggers who stop you in the street and try to sign you up to whichever charity they're being paid by to do that day. I've known people who've done that job, and it's not an easy one. And similarly, any member of this House who stood in a precinct trying to sell their political brand and also get people to sign up will completely attest to that. But sometimes these charity collectors are successful and the all-important direct debit details are extracted. Indeed, I remember hearing a number of members opposite railing against this practice in the last Parliament. So this Amendment 292 reminds workers that they still have an off-ramp if they want one. They still have agency and they still have freedom of choice. We've heard member after member stand up over the past 2 days of debate and declare, in some cases sheepishly, in some cases more proudly, the money they receive from the trade unions. This is only right and proper. The public can make up their own minds as to whether this money has coloured members opposite's judgment or whether it is simply support from an organisation which shares their values. But to turn down Amendment 292 would, in my view, be a dreadful look. The amendment is totally measured, it's a totally measured balancing amendment, and if members opposite vote against it, I think the public would be right to conclude that the government is not being motivated by a sense of equality, fairness and justice, but instead by something else. So I urge honourable members to vote for Amendment 292 and to give power to the people.
Andy MacDonald.
Thank you, Madam Deputy Speaker. It's a pleasure to be called to speak during this report stage for a second time. And I refer the House proudly to my entry in the Register of Interests as a member of Unite the Union. Much has been said about trade unions and about strike action, as if the only purpose for trade unions is to get workers out on strike. I think it's a mischaracterisation, as so eloquently described by my honourable friend. And it's also a mischaracterisation of corporate Britain to think that everyone is exploitative and abusive. The majority of companies in our country adhere to social governance and environment, social governance. They make that commitment. They want to demonstrate that they are responsible people. They want that for their investors and for long-term sustained investment. So I think we've got to draw back on this and step away from the disdain and the contempt for working people and for trade unions. It's not helpful. Madam Deputy Speaker, I'll move on to the substantive issues. But with regard to Government Amendment 250, I wish to express my support for the strengthening of the role of the Fair Work Agency, enforcing the decisions on pay by the new negotiating body for social care. Adult social care was the sector uppermost in our thinking when considering the concept of fair pay agreements, negotiated through sectoral collective bargaining as expressed in the New Deal for Working People. I noted during the Bill's committee stage that the TUC General Secretary Paul Novak said bodies as disparate as the International Monetary Fund and the OECD have talked about the benefits of unions and collective bargaining in modern economies. Benefits in terms of improved productivity and business performance, but also benefits for workers in terms of increased pay. The TUC has said we would like the bill to include powers to extend fair pay agreements to other sectors. I wholeheartedly agree with that, but FPAs of themselves do not remedy the broader need for much greater sectoral collective bargaining. Unite the Union has said we would like to see further measures in the bill to extend collective bargaining, and the RMT General Secretary said we would like it very straightforward that there is going to be a provision, an amendment for sectoral collective bargaining. But so as to ensure that the government can establish new negotiating bodies supporting fair pay agreements elsewhere in the economy, I've tabled new clause 68. A good starting point for the government to demonstrate the benefits of sectoral collective bargaining would be in the civil service. And I hope the plans to modernise the civil service will end the inefficient situation of hundreds of separate pay bargaining units and negotiations each year. And I want to consider private sector contracting. The Deputy Prime Minister and the Chancellor are amongst those who have committed to the biggest wave of insourcing in a generation, and I look forward to the national procurement policy setting that out. But in the meantime, we've seen picket lines on government departments for months as G4S, ISS and OCS fail to meet with the PCS union to resolve pay and conditions disputes. So my new clause 66 would ensure that the Secretary of State has a duty to ensure that any government department or similar public contract recognises an independent trade union for the purposes of collective bargaining. I hope the government will be addressing this out with the bill in the near future. With regards to access, Madam Deputy Speaker, a number of new amendments by the government clarify the process around access, including the right to communicate with workers, including digital communication. But I remain concerned that the process creates a complicated framework which risks employers slowing the process, rather than providing for effective union access that the proposed model of financial penalties does not provide any remedy for the union. I remain of the opinion that unions should always have a simple right of access to their members. My new clause 70 sets out how an official of an independent trade union shall have the right to enter premises to meet, represent, recruit and organise workers and to facilitate collective bargaining. And I make clear that such access requires prior notification in writing, setting out the purpose of a meeting and which employees would join such a meeting. I fear the process set out may not work effectively, and I hope the government will be open to further simplification in the future. And on recognition, I note that the government new Schedule 2, which updates the original Clause 51 with additional and welcome provisions on union recognition processes, including preventing employer inflating the bargaining unit with transferred employees, a la Amazon, where workers were ascribed to that bargaining unit, had no connection with them whatsoever. And it so as to prevent employers reaching a recognition agreement with a non-independent union to prevent recognition with an independent one. We must not, the government has been absolutely right to close off the sweetheart deal arrangements. But more can be done regarding recognition, which is why I tabled Amendment 271, where I've sought to reduce the need for a ballot and to ensure that the Central Arbitration Committee grants automatic recognition in certain circumstances, or be a simple majority of those voting in other circumstances. I've also sought to lengthen the period for making a complaint about unfair practice in connection with the ballot from 1 to 20 working days. I know the government have shifted that from 1 to 5, but that is as per many unions and TUC have set out, and the need to remove the 3-year barrier to a union which has lost an application for recognition, to substitute 3 years with 3 months. It is unjust that the GMB cannot quickly pursue a recognition process at Amazon's Coventry warehouse, particularly given the anti-union measures deployed, where the union lost, as we previously heard, just by 29 votes. It's unjust that they should be pushed out of that for such a long period. And I hope the government will remain alive to the need to update that. So, in conclusion, Madam Deputy Speaker, I'm pleased to have been afforded the opportunity to speak for a second time in this debate. We have in this Employment Rights Bill a momentous uplift in workers' rights and protections, which does address the balance that has swung far too far in the opposite direction. But the appetite remains for yet further improvements, and I commend the government for its work in bringing forward this legislation, which I wholeheartedly support, and I look forward to further working together on the journey to deliver well-paid, secure and unionised employment. Thank you.
Chris Law.
Thank you, Madam Deputy Speaker. And while I broadly welcome this bill as its progress through this House, I've caveated it by stating the Labour Government should be bolder and must go further in the future in order for these rights and protections to become entrenched rather than rolled back on. Indeed, at the second reading, I quoted the Scottish Trade Union Congress General Secretary Ross Foyer, who summarised this bill by saying, and I quote, "The Employment Rights Bill isn't the terminus, it's the first stop. This can be the foundations on which we can build." I agree. However, Madam Deputy Speaker... Yes, I'm happy to give way.
Antonio Bance.
I thank the Honourable Member for giving way, and the Honourable Member may not have had a chance to look at the government's website and encounter the document Next Steps to Make Work Pay, which sets out a programme of continuing work to improve rights at work, which will continue with the work to improve parental leave and the review of employment status to come. I'm sure he'll be glad to hear that.
I would have to, and thank you for the intervention. No, I haven't had the chance to look at the government website, but thank you for raising these clear points. But as I've broadly said, I support this bill. But there are reasons why I'm bringing up this debate today, not least because of the lack of devolution to the Scottish Parliament, which I'll come to shortly. Madam Deputy Speaker, also at second reading, the then Shadow Minister made it explicitly clear that these will not be built upon in the long term, as a future Conservative government would simply repeal protections when they declared, and I quote, "Many of the measures will be brought in through secondary legislation, therefore making it easier for a future government to reverse some of the catastrophic changes." Madam Deputy Speaker, employment rights for workers in Scotland cannot be dependent on the merry-go-round of Westminster politics. They have seen their rights attacked and diminished by years of Conservative governments, and where this bill reverses some of the worst excesses of their policies, this must be protected and strengthened in the long term, something Westminster cannot guarantee for the people in Scotland. I therefore propose, Madam Deputy Speaker, new clause 77, amending the Scotland Act to devolve employment and industrial relations to the Scottish Parliament. Madam Deputy Speaker, back in 2014, when all unionist parties, including the Labour Party, were promising maximum devolution for Scotland, as displayed on the front page of a national newspaper days before an independent referendum in Scotland voted no, this Labour government has failed to devolve a single power to Holyrood since coming to power in July, not a single one. This is despite the Scottish Parliament voting for employment rights to be devolved. In November, the SDUC calling on the UK Government to, and I quote, end excuses and devolve powers over taxation, migration and, importantly, employment law from Westminster to Holyrood. Moreover, Scottish Labour's 2021 election manifesto stated, and I quote, we support further devolution of powers to Holyrood, including borrowing and employment rights. So today, here is a question for the Scottish Labour MPs. Will they respect the wishes of the Scottish Parliament, listen to trade unions? No, I see you shaking your head, but I'm speaking to Scottish Labour MPs. I hope you don't mind me saying. Respect the wishes. I care about the people of Scotland and what they say. Will they respect the wishes of the Scottish Parliament, listen to trade unions and deliver on the promises made by their party by supporting this amendment, or will they continue to follow instructions handed to them from number 10? Oh, silence. I thought so. Too scared to stand up for the people of Scotland. That is why... Yes, please.
Johanna Baxter.
Thank you, Madam Deputy Speaker. I thank the honourable gentleman for giving way. I note he is advocating that he is a big supporter of workers' rights. I just wonder if he'd like to comment on the fact that for every year of the last 8-9 years, when I was a lead negotiator for local government workers in Scotland, they had to have consultative ballots for industrial action just to get a decent pay rise out of the Scottish Government. Does that really mean that you're standing up for workers in Scotland?
Chris Law.
Madam Deputy Speaker, I thought I was asking a question of the Scottish Labour MPs only to be replied with a question, but to respond to your question, respond to the member for Paisley in Renfrewshire, South's question. As you'll be well aware, the Scottish Government has worked collectively with both unions and with other bodies to make sure that the living wage in Scotland is paid higher than any other parts of the UK. But I just remind the honourable member that indeed it was Scottish Labour in November 2023 who voted with the SNP for employment rights to be devolved through the Scottish Parliament. Madam Deputy Speaker, throughout this existence, when powers are devolved to Scottish Parliament, decisions are taken in the interests of the people of Scotland and outcomes improve. Publicly owned rail and water, higher per head education and health spend, free prescriptions and free tuition, a more humane welfare system, a progressive taxation system. Madam Deputy Speaker, fair work practices are being delivered already by the SNP Scottish Government, such as supporting collective bargaining, achieving real living wage employer status, and closing the gender pay gap, if I just finish my point, please, and closing the gender pay gap faster than anywhere in the rest of the UK. Happy to give way.
Katrina Murray.
Thank you very much, Madam Deputy Speaker. On the point that the honourable gentleman has made about collective bargaining, would you agree with me that it is an absolute failure of collective bargaining for the Scottish Government to have walked away from the commitments that they made within a deal with health service unions 2 years ago on the reduction of the working week, where they are failing to reduce, to basically go through with what they agreed on and to reduce the working week as of the 1st of April 2025 by half an hour.
I listened with interest, but I think I'd just refer to the member for Cumbernauld and Kirkintilloch to have that debate in the Scottish Parliament after we're talking about devolution of the powers here in the UK Parliament. On collective bargaining, a point has just been raised. A framework for this in the adult care sector has been developed by the Scottish care unions. Unison, GMB and Unite along with the Scottish Government and care providers, with a Scottish Social Care Joint Council proposed. The Scottish Care Unions have intimated that the constitution, composition, remit and function of the Scottish Social Care Joint Council is preferable and should assume the role of the audit social care negotiating body for England. Madam Deputy Speaker, Scotland already has a 10-year history of joint commitments to fair work, whereas England is now only embarking on that journey. Furthermore, there is a need to extend sectoral bargaining to all sectors of the economy, not just adult social care. Measures such as creating a single status of worker for all, but the genuinely self-employed, to strengthen protections for those with unfair contracts, and increasing the minimum wage to at least the level of the national living wage and then in line with inflation, are all missing from this bill. These would be supported by the SNP. Scottish Government, if employment law was devolved, and would be delivered if this Government respected the votes of the Scottish Parliament and the Scottish Labour Manifesto. Madam Deputy Speaker, just as this bill should be the first stop rather than the terminus, devolution is a process, not an event. Not only is devolution moved at a glacial pace, we live in the world's most asymmetrical political union, where each nation has differing devolved powers from each other. So whereas in Northern Ireland has employment law devolved, why is it the case that Scotland does not? I want to see employment rights continually strengthened rather than a cycle of piecemeal progress, when Labour in power, only to be reversed when the Tories next get their turn. Therefore, the gains that this bill will make to workers' rights must be protected. It is for that reason that the SNP remains committed to advocating at the minimum for the urgent devolution of employment powers as the best way, short of independence, to protect workers' rights in Scotland. Thank you.
Thank you, Shanker.
Thank you, Madam Deputy Speaker. I also refer the House to my register of business interests and also have been a proud member of Unite the Union for over 35 years now, although I know many of you may find that hard to believe given my youthful looks. Absolutely. I welcome the measures in this bill, which I know will make a real difference to the lives of working people and their families in Derby and across the UK. With reference to Government Amendment 163, I want to focus today on how the bill will transform employee access to trade unions, empowering more employees to act as a collective so they can secure better pay and conditions. Because when I speak to leaders, business leaders across small and large employers, they will all say that their biggest asset is indeed their people. The Conservatives can harp on as much as they want about trade unions, but in practice, the best solution is when employers working with employees and trade union reps create the best working conditions for businesses and the individuals to succeed. And the importance of trade union membership is something I know firsthand too. When I left school at the age of 16 and began work as an engineering apprentice, I joined the union on day 2. I knew how important it would be in supporting me and my colleagues at work. And much later on, when campaigning to save Alstom in Derby just last year, I saw how hard Unite, amongst other trade unions, fought to secure jobs at the Litchurch Lane facility. They stood up for working people in our local community when it mattered most. But employees can't access the benefits which union membership can bring if they don't know about the support offered by trade unions in the first place.
Will my honourable friend give way?
Yes, absolutely.
I thank my friend for giving way, and can I congratulate him on his youthful appearance? Would my honourable friend agree with me that much like businesses are about their employers, trade unions are actually about their members and their membership, and actually what it's about is actually giving those members, the members the rights, not the rights of the unions, but the rights of the individual members?
I thank my honourable friend for that intervention, and he's absolutely right. This is about individual members coming together to do what's right for themselves, their trade unions, the companies and businesses that they work for. So I welcome the bill, and it will introduce the right of access for unions to meet with workers. Government Amendment 163, introduced today, expands union access agreements so that unions can communicate with workers digitally as well as by entering the workplace. I urge that these digital access rights are implemented meaningfully to enable direct conversations between unions and workers, as would take place during an in-person meeting in the workplace. When we work together, we get more done. Because of that, it is important that workers have access to union representatives so they know how joining a union can support them in the workplace. I welcome the measures outlined in the bill to expand this access, which will further strengthen the rights of working people in Derby and beyond.
Yeah. Sarah Ball.
Thank you, Madam Deputy Speaker. There are 5,310 businesses registered in my constituency of South Northamptonshire. Of these, 99.6%, or specifically 5,245, are small businesses. This bill, amongst many of the government's policies, is a calamity for these small businesses. Not only are many of these rural, meaning they'll be affected by the family farm tax and now the removal of SFI, but as the chair of the Federation of Small Businesses has said, these SMEs will struggle to adapt to the 28 major changes that this bill makes to employment law. First, it was their jobs tax, Madam Deputy Speaker, then it was their cuts to rate relief for hospitality businesses, and now they're smothering them with red tape. Analysis published by the Department for Business and Trade says that this will impose a direct cost on businesses in the low billions of pounds per year. But this is not money that many of my small businesses can afford right now. This is why we on this side of the House have called for small businesses to be exempt from parts of this bill that would heap unsustainable costs on them. Why does this government seem to hate small business so much? Is it perhaps because the majority of the Cabinet have spent their careers in the public sector with zero understanding of what life is like for many entrepreneurs with SMEs across the UK and in my constituency? We learned this week that for the first time since records began in 2012, the number of companies registered at Companies House has fallen. Growth forecasts have been downgraded. The number of vacancies has declined. All this as a result of the choices the government has made and continues to make in this bill. With all of this, the UK risks becoming a globally uncompetitive economy, particularly when other countries like the United States are slashing regulation and unleashing their businesses to grow their economies. The opposition has tabled new Clause 90 for exactly this reason. This amendment would ensure that when the Secretary of State was making regulations under Part 4 of this bill, he would have to have regard to growth in the medium to long term. And I join the Shadow Minister in calling for the government to support new clauses 89 and 90 to ensure this growth. Our economy is already struggling under the weight of Labour's tax rises. Why are they opposing our efforts to ensure they consider how burdensome regulation might impact businesses? Of course.
I'm grateful to my honourable friend for giving way, and I think the answer to that question, a lot of people outside may feel, is because the trade unions have funded members opposite. The honourable member who just spoke, who's talking from a sedentary position, received more than £27,000 in the latest year of declarations from two unions and didn't think it appropriate in this debate even to mention that number, which may well have influenced his thinking and led to the dire outcomes which my honourable friend is explaining to the House.
Well, I thank my honourable friend for that, and it is a very powerfully made point, and I think all members opposite must really reflect on this, because we do need the public to understand truly why this legislation is going through. That the government has also seen fit to table, just at this stage alone, 87 of its own amendments is indicative of how uneasy it must feel over this bill. And we're even told by the media that the Treasury has warned the Deputy Prime Minister and the Secretary of State about the consequences of enacting these laws on our economy, yet they seem to have seen fit to plough through anyway. As per usual, Madam Deputy Speaker, this is Labour paying lip service to growth while sticking to true form with their socialist ideology. Absolutely. I wasn't born in the 1970s, Madam Deputy Speaker, but it appears that I'm going to live the equivalent of that in the years ahead as the benches opposite play ABBA's 1976 hit Money, Money, Money for their trade union paymasters.
Zara Sultana.
Thank you, Madam Deputy Speaker. I refer the House to my register of interest. I'm a proud trade unionist, a member of Unite the Union, and I've been supported from across the Labour movement with the cleanest money in politics, which I don't think members opposite can say for themselves. Madam Deputy Speaker, for over a year, Swedish Tesla workers have been on strike, demanding the basic right to collective bargaining. Their struggle has inspired solidarity across industries. Postal workers, painters, electricians, cleaners and dock workers have all launched secondary action in support. Denmark's largest trade union, 3F Transport, has also joined the fight, preventing Danish dock workers and drivers from handling Tesla shipments bound for Sweden. This level of solidarity is possible because Swedish trade unions are not shackled by restrictive laws designed to suppress collective action. Unlike here in the UK, the legislative landscape in Sweden does not act against the interests of organised labour. Almost 90% of Swedish workers are covered by collective agreements, and their labour laws ensure that workers have the right to negotiate and defend their conditions without undue interference. As a result, Swedish trade unions are more than a match for a billionaire like Elon Musk. When Tesla refused to sign a collective agreement, it wasn't just Tesla workers who fought back, the entire trade union movement did. Madam Deputy Speaker, this is what real industrial democracy looks like, and is a powerful reminder of what British workers have been denied for too long, with some of the most draconian anti-union legislation in the Western world. While I welcome the repeal of the Minimum Service Levels Act and much of the Trade Union Act 2016, the fact remains that many of the worst Thatcher-era anti-union laws are still in place. One of the most damaging is Section 224 of the Trade Union and Labour Relations Act 1992, which makes secondary action unlawful. This ban on sympathy strikes isolates workers, weakens their bargaining power and prolongs disputes, all to the benefit of exploitative employers. That's why I have tabled New Clause 31 to repeal this restriction and return power to working people. Secondary action built the trade union movement as we know it. It helped to secure the very rights that we all benefit from today. But in an era of outsourcing and subcontracting, the ban is even more harmful than it was 3 decades ago. Under current legislation, 2 workers performing the same job in the same workplace can't take industrial action together if one is directly employed and the other outsourced. Employers exploit this loophole to divide workers, shift responsibility through complex corporate structures like what we're seeing at Coventry University in my constituency, and undermine union action by transferring work or hiving off companies. Workers are even prevented from taking action against parent companies and suppliers during disputes. In many ways, Madam Deputy Speaker, secondary action is more essential than ever in the fight for fair pay and conditions. Most European nations, including Denmark, Norway, Sweden, Belgium and the Netherlands, allow secondary action in some form. Even those with restrictions like Germany, France and Spain stop short of imposing an outright ban. Madam Deputy Speaker, Labour's New Deal for Working People committed to repealing anti-union laws and ensuring that the UK's industrial action laws comply with international obligations, including those under the International Labour Organisation and the European Social Charter. Yet, as it currently stands, this bill fails to deliver on that promise. International bodies have repeatedly condemned the UK's ban on secondary action. The European Committee on Social Rights and the ILO criticised the UK for this restriction, most recently in 2023 after the P&O ferry scandal, where 800 crew members were sacked via video call and replaced with agency workers. P&O knew that they could get away with their disgraceful actions because the law prevents other workers from striking in solidarity. I'm also supporting a number of amendments, including those tabled by my honourable friend, the member for Middlesbrough and Thornby East, such as New Clause 61, which would define employment status in law to end bogus self-employment. This is long overdue. For too long, employers have exploited gaps in employment law to deny workers basic rights. Today, in our country, Black and Asian workers are disproportionately trapped in precarious, low-paid jobs on bogus self-employment contracts, denied statutory sick pay, holiday pay, and protection from unfair dismissal. This two-tier system must end. Every single worker deserves dignity and respect in the workplace. And by strengthening this bill with these amendments, we would be taking a step forward towards rebuilding the power of the working class. I urge members across the House to stand on the right side of history and with the workers who keep this country running.
Gregory Stafford.
Thank you, Madam Deputy Speaker.
Speaker, and I rise again today to speak on this second day of the bill to raise serious concerns about the role that this bill will have in facilitating unprecedented and dangerous access and destruction of business, especially small business. I'm glad the Minister is in his seat, because yesterday he was challenged to name a small business that supported this bill. 24 hours later, he still cannot. And that is not down to the assiduity of the Minister, who I'm sure is very assiduous, but the simple fact that no small business supports this bill. Yesterday, I've hardly started. There can't be possibly anything he wants to intervene on me just yet, but I will come to him in a minute. Yesterday we discovered, I will come to him in a minute. Yesterday we heard that Labour clearly doesn't understand business. And today we get to what they really do understand, which is how they can support their trade union paymasters. And members opposite have given an absolute masterclass in telling us about how to support trade unions. Honourable members on this side have mentioned the 1970s. But, Madam Deputy Speaker, when I heard some honourable members speaking on the other side, especially the member for Blyth and Ashington, the score of John Williams soared in my mind from Jurassic Park. But instead of Jeff Goldblum being savaged by the dinosaurs that walk amongst us today will be savaging our economy. And we know that because the growing influence of the unions, especially within this bill, impose a heavy burden on corporations, stifling their ability to operate efficiently. And as new businesses struggle to adapt to these new regulations, predicted in the government's very own impact assessment, which is going to cost £5 billion, industry leaders have publicly shared their fears over...
Point of order. Andy MacDonald.
Madam Deputy Speaker, we've had directions from the Chair, and I'd ask for your guidance on this. We've just had the Speaker be immensely critical of an honourable member whose history is standing up to defend his industry and had the courage to go out and strike for 12 months, and he has not, to my knowledge, I'd like to ask the question, has he been given notice that he would be named in this debate in that way?
I thank the honourable member for his point of order. He will be aware that that was not a point of order. And as the honourable member for Blyth Valley had spoken in this debate, it's perfectly in order to refer to the comments that he had made. Gregory Stafford.
Thank you very much, Madam Deputy Speaker. And I return to what industry leaders are saying. They've shared, and I quote, their fear over union influence slowing down decision-making and hindering flexibility, making it harder for companies to remain competitive in global markets. Indeed, the Chartered Institute of Personnel and Development survey found that 79% of organisations expect measures planned as part of the Employment Rights Bill to increase employment costs, placing further strain on companies having to grapple with the increases in national insurance contributions, the rising national minimum wage, while it being likely, while it being likely that these will continue to lead, and I quote, to more strikes, more disruptions, and ultimately less productivity. I give way to the honourable member.
The honourable member has referred a number of times to the proceedings yesterday, and one of the things I'm saddest about is that the honourable member for Farnham and Borden was not able to join us in the division lobbies voting against the amendments and in favour of the bill yesterday, given that 73% of his constituents in Farnham and Borden support statutory sick pay for all workers from day one, and 67% of his constituents support banning 0 hours contracts.
Well, I'm sorry that I'm such a disappointment to the honourable lady, but maybe she will get over it. This is a rollback of the most important changes that we made when we were in government. And it's no surprise, therefore, that the trade unions have warmly embraced this legislation, with over 200 amendments hastily shoehorned to satisfy those who line the government's pockets. Perhaps it's purely coincidental that their wishes have been granted, though one might wonder if the £5.6 million in donations the Labour Party has received since July had something to do with it. Very happy to.
I'm grateful to my honourable friend giving way. The last Labour member to speak also, despite her proud membership of trade unions, didn't mention the more than £9,000, I think, that she received just in the last year, any more than her predecessor mentioned the £24,000 plus that he received. If Labour were truly proud of the way they've been bought and paid for by the trade unions, perhaps they could be open about how much they've received.
Stafford.
Well, my honourable friend makes an absolutely key point. And what's been interesting, I think, the change from yesterday to today, where yesterday actually, whilst they were very clear to declare that they were members of trade unions, only today have they suddenly realised that they should be declaring the amount of money that they are receiving directly. And we heard yesterday from the Shadow Secretary of State for Levelling Up that this legislation will allow unions to bypass current rules, such as opting out of political donations. It must be absolutely fantastic news to the party opposite that Labour will now receive default donations from workers, while businesses will face reduced notice periods for strikes, leading to even more disruption and economic damage. It's clear to me, and the hundreds of businesses that pulled their support for this government, this isn't about protecting employment rights, it's about consolidating union power. Let's look at some of those amendments briefly, Madam Deputy Speaker. Amendment 292 will require trade unions to notify their members every year of their right to opt out of the political fund and to obtain an annual opt-in. This change ensures that the unions continue to fill Labour's piggy bank, locking workers into automatic donations unless they actively opt out, which is much a memory test as an admin task. This is not about transparency, Madam Deputy Speaker. It's about keeping money flowing to the political party with the most to gain. Likewise, the clauses and amendments which would have introduced transparency around the facilities provided to trade union officials, learning representatives and equality representatives. These amendments are designed to reduce transparency and accountability for union spending, allowing union officials to continue to benefit from facilities time without proper scrutiny. I will, the last time, yes.
I thank my honourable friend for giving way. Does my honourable friend think there's quite an interesting contrast in terms of the government's approach? It's quite happy to put extra burdens, responsibilities and work on small businesses and businesses of all sizes. Yet when it comes to any element of transparency or any element of giving members of trade unions a real choice and understanding of where their money's going, they refuse to do that.
Gregory Stafford.
The disparity, I put it no stronger than that my right honourable friend mentions is stark. And I think anybody watching the proceedings outside this House will absolutely agree with him that, on the one hand, they want to put extra burdens, extra regulations on business, but when it comes to the trade unions, transparency goes out of the window. And why, as my right honourable friend said, why is this happening? The answer is simple and clear. Unions have significant influence over this government. And while the Deputy Prime Minister and her Cabinet colleagues are pushing for the changes, they don't even follow them themselves. Clear key figures, including the Chancellor, the Foreign Secretary and the Home Secretary, are all guilty of hiring under terms that are at odds with these new regulations. Why would they introduce such a bill when they themselves don't comply with it? And it's just like the more than 200 Labour MPs who've taken union donations. The Deputy Prime Minister has her own interests to consider. Yesterday, in her opening remarks, she proudly disclosed her union membership while conveniently admitting the £13,000 in union donations that she has taken. To me, it is clear that union influence is driving this legislation and most likely writing the speeches of the party opposite. For a government who claims to be pro-growth, pro-business and pro-worker, and that's a quote, perhaps it's time they start... I won't, because I've only got a minute to go. It's time they started listening to the real industry experts, those with practical experience within the sector, not just the trade unions or the confines of Whitehall. That is why the Conservatives have tabled the key amendments to support growth in New Clause 89 and New Clause 90, international competitive duty in New Clause 87, and a limit on trade union influence on our business-driven economy. Madam Deputy Speaker, we need to ensure that the government's policies do not burden our businesses, do not stifle innovation, or lead to long-term economic harm. This bill isn't just poorly thought out, it's a direct threat to the very fabric of our economy, and we must challenge it before it causes irreparable damage and crushes our already crippled economy.
Dr Alison Gardner.
Thank you, Madam Deputy Speaker. Firstly, can I declare that I am a proud member of Unison and I refer the House to my register of members' interests. I rise today in support of this groundbreaking employment rights bill, which will deliver reforms that are pro-business and pro-worker. This bill will establish from day one rights such as parental and bereavement leave for millions of workers. And this bill will crucially put more money into people's pockets, people who have had to endure low pay, job insecurity and a cost of living crisis created by 14 years of Tory rule. By strengthening protections for the lowest paid workers and preventing exploitative employment practices, this will give our working people the solid foundations to build a better quality of life. And I want to just very briefly comment on a couple of topics debated yesterday as relevance to personal relevance and to my constituency. No? Shall I skip it? I'll skip it. Okay. I didn't think I'd get away with that. Right, so thank you very much. So basically, this this bill will give a voice to working people by tackling the exclusion of independent unions from workplaces. If anyone has experienced a change of management, a management of change process, which I once did almost 3 weeks into joining a new job, which was not fun, or workplace bullying, they will know the value of having a union backing you. They are fab, and I will personally thank Unison who have supported me in my workplace, including the incredible Trudy. And I have seen personally, not myself, but the impact on others when they've experienced issues such as workplace bullying, when they haven't had the backing of a union, or indeed a union in that workplace. And the stress and the pressures on them have been immense. And indeed, they've got the choice of either put up with it, leave, and then you've got worker turnover, or go off sick. And I've known people to go off sick for quite a period of time, and that has, of course, great cost to the company. I have also seen that when a person actually then turns around and joins a union, the difference that backing has, that advocacy has for them, and the voice that that gives them. And having experienced this as a normal person who once had a proper job and was not a union activist, but just had that value of unions, this is a comment I take as an observer, the work that they do in working with management and working for the workers to provide a working place that is productive, that is secure, benefits the companies as well. It is not in the union's interest for businesses to fail, for companies to fail. Everyone wants a productive working environment. So finally, it would be remiss of me not to acknowledge the concerns, however, of many small business owners that have been raised with me in recent months. They have been worried by this. And I am grateful to many businesses who have reached out, including 1882 and Crossroads Care. And I also want to mention Rachel Lavery, the Chamber of Commerce, for her excellent engagement and giving voices to local business. And I've been regularly engaged with them. The concerns are noted, but I note also the comments such as that from Claire Costello, Chief of Police, I've given her a new job, Chief of People and Inclusion Officer at the Co-op. It's our belief that treating employees well, a key objective of this bill, will promote productivity and generate the economic growth this country needs. And this comment has actually been echoed to me by local businesses also. So to my businesses in Stoke-on-Trent South, they have my word, I will support them and their workers, and so will this Labour government in delivering improved productivity and growth. I am sad to see the party opposite do not want to support the working people of this country with their blocking amendments. Madam Deputy Speaker, this bill and the comprehensive set of impact assessments shown that this bill will have a positive impact on growth, with vital measures like sick pay, boosting productivity and growth. Protecting the super-rich and relying on the myth of trickle-down economics has failed. It is time for trickle-up economics and empowering the working people of this country. Thank you.
Alison Griffiths.
Thank you, Madam Deputy Speaker. As has been said many times yesterday and indeed today, this bill is deeply flawed. Yes. The government has ignored the serious concerns raised by business leaders and independent economists. The Federation of Small Businesses warns that the rush changes will lead to job losses and deter employers from hiring. The Institute of Directors found that 57% of business leaders will be less likely to hire because of the additional red tape this bill imposes. And incredibly, the government's own impact assessments fail to account for the real economic consequences, simply dismissing them as too hard to calculate. Our new Clause 90 would ensure that any regulations under Part 4 of the bill must consider economic growth and international competitiveness. Yet Labour has refused to accept even this common sense measure, proving that their approach is anti-growth at its core. Prioritising the interests of trade unions over economic stability makes it harder for businesses to hire, grow and compete. It's no surprise that trade unions have declared victory, as the government has effectively handed them a blank cheque at the expense of businesses and workers alike. Our amendments seek to restore fairness and balance. Amendment 292 would require trade unions to notify their members annually of their right to opt out of political fund contributions, ensuring basic transparency and fairness. Yet Labour has hypocritically opposed this measure, despite previously supporting similar provisions in the Digital Markets Bill, where they called automatic renewals a subscription trap. It seems Labour only cares about consumer choice when it doesn't impact on its own funding. The government claims that removing this requirement is about cutting red tape, whilst adding lots of other red tape, for unions. In reality, it strips away individual choice and accountability. Between 2019 and 2024, as several of my honourable friends have already said, trade unions donated over £31 million to the Labour Party. Workers should have the right to make an informed choice each year about whether they want to contribute to political causes rather than being automatically signed up without clear consent. Labour's refusal to support this amendment reveals their true priority, protecting their own financial interests rather than standing up for transparency and worker rights. Equally troubling is the expansion of trade union access to workplaces, including digital access, under new clauses 163 to 181. Despite 59% of consultation respondents asking for more information or outright opposing this provision, the government is pressing ahead regardless. These changes hand unions unchecked power, allowing them to disrupt businesses without adequate safeguards. This bill is not a modernisation of employment rights. It is a gift to the trade unions at the expense of economic growth, job creation and business confidence. The government has failed to strike the right balance, and we will continue to oppose this legislation. So I didn't hear you, but please, I will happily give way to my honourable friend.
I'm grateful to my honourable friend for giving way. The impact assessment does say that these measures could have a £5 billion impact, in addition to the £25 billion impact of national insurance contributions. But does my honourable friend agree with me? What's missing is an assessment in the impact assessment. Just how much will these measures drive of union funding direct to the Labour Party as a result of this? Because we ought to know how many hundreds of thousands or indeed millions extra will come to the Labour Party and the members opposite to make them support this growth-killing set of measures.
Alison Griffiths.
I thank my honourable friend for his intervention, and it is a fascinating question, and I'm sure we will be waiting to hear from the members opposite what the answer is, and perhaps even the Minister. Thank you.
Gregor Poynton.
Thank you, Madam Deputy Speaker. It's a pleasure to speak today as this vital bill passes its remaining stages, and I draw the House's attention to my register of interests. I'm a proud member of both the GMB and community trade unions. Madam Deputy Speaker, I'm particularly pleased to speak in today's debate because at one of my regular coffee mornings on Saturday, a constituent of mine, Phil, came to see me to say I needed to be doing more to promote the benefits of this legislation. Now, I'm not sure that making a speech in the House of Commons would meet Phil's expectation of promotion, but it did show to me that conversation, just how important that this legislation will be for working people in the Livingston constituency. Madam Deputy Speaker, the Government has rightly tabled amendments to the Employment Rights Bill to make sure we deliver both reforms that are both pro-business and pro-worker. Those on the benches opposite have tried to make much of the number of the government amendments to this legislation. However, Madam Deputy Speaker, we remember they are still the party of F business, and with their opposition to this bill, we shows they are F workers too. Madam Deputy Speaker, with what these amendments in fact demonstrate is the commitment of the Minister and the Government to listening and consulting with a huge range of stakeholders across these issues, delivering the largest upgrade in workers' rights in many decades, but doing so in a way that does right by businesses and good employers to ensure they have the conditions and environment they need to encourage investment and create jobs. Madam Deputy Speaker, this bill will support the Government's critical mission for growth by increasing productivity and putting money back in people's pockets. It will deliver real-life improvements. Go ahead.
And set out 5 ways that this bill will improve productivity for businesses.
Certainly come on to that, how that, well, for one, improving the employment relations between workforces. In the last 14 years, what we've seen is strike after strike because of the party opposite's approach to industrial relations. I think that will improve productivity. It will deliver real-life improvements that will be felt across Britain. Key amendments that strengthen protections for the lowest paid workers will ensure that all workers are treated with decency they deserve. And I welcome the vital steps this bill takes to extend protection from exploitative zero-hours contracts, protect the voice of working people and strengthen statutory sick pay. As a member of the Business and Trade Select Committee, I've been able to scrutinise large businesses who choose to have zero-hours contracts in place. In one evidence session, I heard from a company representative who revealed that employees can have their shift changed at 24 hours' notice, but do not receive a single penny in compensation for that. This bill is vital in addressing the challenges of financial planning that families dependent on zero-hours contracts face. Over 1 million people on zero-hours contracts will benefit from the guaranteed hours policy. And crucially, this bill will ensure that the Government works with businesses who support employers to endeavour to comply with the law. And the Government amendments under discussion today, it will also expand and strengthen the powers of the Fair Work Agency to bring civil proceedings against non-compliant employers at the Employment Tribunal and to issue civil penalties like fines to employers breaching pay-related rights and underpaying their staff. Of course.
Given the measures we're debating today will give so much more power to the trade unions, is there a reason why the Honourable Gentleman hasn't felt it incumbent upon him to declare the thousands of pounds specifically that he has received from trade unions in the last year?
Thank you very much, Honourable Member, for highlighting that. I'm proud of the money that I received from unions. I'm also proud of the fact that entrepreneurs and business people donated to my campaign as well. You neglected to mention that, didn't you, when you brought that up? Right. So because I'm both pro-business and pro-worker, I want to see growth in the economy, and I'm proud to receive donations from employers and people who have created wealth in this country. I'm also proud to receive donations from trade unions and members in my constituency. Yeah, go ahead.
I'm grateful to the Honourable Member for giving me. Is he surprised, as I am, that there seems to be so much support on these particular benches for maybe caps on political donations and greater transparency on political donations too?
Shouldn't that, of course, but that is absolutely the case. You know, I would love to see more transparency coming from the party opposite. Madam Deputy Speaker, it is right and proper that we reward good businesses that contribute to good employment and sustainable growth, and it is right and proper we take action against rogue employers that do not. With this bill, the Government is also calling quits on the Tories' scorched-earth approach to industrial relations that led to the worst strike chaos in decades. A new partnership of cooperation between trade unions, employers and Government will ensure we benefit with more cooperation and less disruption. North of the border, Madam Deputy Speaker, this bill signals the largest upgrade in workers' rights in Scotland for a decade. It marks an end to exploitative zero-hours contracts and fire and rehire practices. It will establish day one rights for paternity, paternal and bereavement leave for millions of workers. But, Madam Deputy Speaker, these measures will also be beneficial for employers in Scotland, helping keep people in work, reduce recruitment costs by increasing staff retention and levelling the playing field on enforcement. Pro-worker and pro-business, Madam Deputy Speaker. The SNP have been calling for the devolution of employment law for many years, including the member for Dundee Central in his speech. However, they have never at any point explained how, beyond banning zero-hours contracts, those powers would actually be used to improve workers' terms and conditions, to increase productivity and accelerate economic growth. However, also it might be nice if the SNP practiced what they preached During the Rotherham by-election in 2023, the SNP chose to use 0 hours contracts to employ people to deliver leaflets. In government, the same party has also chosen to include 0 hours contracts with their definition of positive destinations for school leavers. Madam Deputy Speaker, financial insecurity, anxiety and stress do not sound to me like a positive destination. The SNP says it wants to transform Scotland's economy for the better, to boost wages and productivity and grow key sectors. But the reality is Scotland has the highest rate of 0 hour contracts among people in employment in any of the UK nations. How are people supposed to plan financially and improve their quality of life when they wake up on a Monday morning to find out via text message whether this week they will have 8 shifts, 2 shifts or no shifts at all? Madam Deputy Speaker, the reality is the Scottish Government already has the powers to introduce many changes to workers' terms and conditions through public procurement, but they choose not to do so. They will always prefer to blame someone else and further constitutional grievance than actually use the extensive powers they have to improve the lives of ordinary Scots. That's why this bill is of such paramount importance. Across the UK, there will be acute benefits delivered to the people who need it most. And in Scotland, this bill will right the wrongs of the SNP's laissez-faire approach to regulating 0 hours contracts. Madam Deputy Speaker, the tenure of the Labour Government is still measured in months and not years, but this bill is another example of it delivering a new direction for workers, businesses and the people of Scotland that the wider UK also deserve.
French. Thank you, Madam Deputy Speaker. And as any sensible people would know, changes to business regulations need to strike a careful balance to not deter both business investment and job creation. But I'm afraid that this bill gets this balance very much wrong. And Labour's weakening of a variety of trade union laws, and particularly the threshold for industrial action, is, I'm afraid, a recipe for disaster for both the public and businesses, particularly those SMEs. And as a London MP, I've heard this fairy tale from the Labour benches before, because London has too often been paralysed by strikes under Mayor Sadiq Khan. Infamously, the London Mayor promised our city 0 days of strikes in 2016, but he has comprehensively broken that promise. In Sadiq Khan's first 2 terms, there were more than 135 strikes. That's almost 4 times more than the number of strikes under his predecessor, a record that Mayor Khan labelled a disgrace. If 35 strikes are a disgrace, then the 135 under Mayor Khan is a catastrophic failure. Madam Speaker, my fear is that this bill and the Labour government's amendments will make strikes even more common in London. And did someone want to come in? Yes.
The honourable member for giving way. Does the honourable member recall how many strikes there were under the last Conservative government?
Thank the honourable member for giving way, but as we've seen already, and this is what I was talking about, the fairy tale, we have this fairy tale that if we improve these relations, then suddenly there won't be the strikes, and if we give trade unions all the money they want, there won't be strikes. Well, what's happening in practice since the Labour government came in? You've given them all the money and they're still threatening to go on strike. And this bill today really does read like a militant trade union wish list. Strike mandates doubled from 6 to 12 months, allowing trade unions to impose rolling strikes for a whole year without balloting their members. Abolishing turnout requirements so a minority can call strikes. Removing the requirement for 50% of members to vote and 40% to support industrial actions. Reducing the notice for strikes by 4 days and giving employers less information. Making strikes even more damaging to businesses and disruptive to the public's lives. Allowing unreasonable paid time facility time for trade unions. Making the taxpayer and companies pay out even more for trade union representatives at the same time that the Labour government are raising everyone's taxes and cutting public services. I'll give way.
I do thank the honourable gentleman for giving way. I'm going to guess that he's never been a member of a trade union or participated in industrial ballot, but just to say to him, members choose to go on strike once the ballot's gone. No one forces them to go on strike. So when members give up a day's pay to go on strike, they do so because they're fighting for improvements in their terms and conditions. He's making out as though somehow it is compelled upon them. When members turn out for strike, it's a strength of feeling for the conditions they face, nothing more.
I would have some sympathy for that argument if the threshold for the percentage of those workers voting for the strikes were maintained. But we are now clearly leaving the door open for a minority of militant trade union members to go on strike and cause mass disruption. And my experience of trade unions, which I'm honest to say that I've never been a member of a trade union, but my experience of trade union bosses in particular, they live a life that I could never dream of as a working class man, to be quite frank. And my history as a working class person from a working class background, I learnt at very young age that the trade unions and the Labour Party stopped representing working class people many, many years ago, and this government is proving it yet again. And I'll give way to the Honourable Lady.
I thank the Honourable Member for giving way. I wonder whether he thinks it's fair, given his comments about a small number of militant trade unionists taking industrial action if this bill is to become law. I wonder whether he thinks it's fair that a small militant group of Conservative Party members managed to elect or choose successive prime ministers throughout the last 10 years with less requirements than members of trade unions had to do in order to take industrial action in their workplaces. Does he think that is fair?
The Honourable Lady for her rather odd intervention, and
Which clause is this on?
And it has nothing to do with this bill today. But I think if more people had chance to vote on issues such as the Prime Minister today, I suspect they would come to a completely different answer than they come to last July. Because this Labour government has broken every single promise that it made at that election, and I can't wait for the public to have the opportunity to vote them out. So I'm all for people having more chance to vote this shocking Labour government out. And Madam Deputy Speaker, returning to my original comments, this bill, as I've said already and has been said by other members on this side of the bench, this is a bill written by the trade unions for the trade unions. And why is the government granting this wish list to the trade unions? The simple answer is because the Labour Party will benefit from these proposals. And as I was taught as a young man, follow the money. Over the last 5 years, the Labour Party has received more than... I didn't follow it by coming into this place. Over the last 5 years, the Labour Party has received more than £31 million in political donations from the unions. This bill would remove the requirement for trade union members to opt into these contributions. Instead, they would have to opt out, which means more would unknowingly contribute to political causes they do not support. The government's amendment would mean that trade unions would no longer need to renew their political resolutions every 10 years. Ultimately, this makes it even easier for trade unions to divert cash to political causes, including the Labour Party. Madam Deputy Speaker, in short, this bill means more strikes, more often, and more money for the Labour Party. Strikes grinding businesses to a halt, shutting down public services, and closing public transport systems again. I'll give way.
Giving way. As he noted in my speech earlier, I think there are problems with the bill, but he mentions the problems on public transport. Does he recall or does he regret that in 2022 the train unions and the train operating companies actually resolved their dispute, but it was the government transport minister at the time who intervened to block that agreement to resolve the strikes?
My experience as an MP, particularly in the out of London, is great frustration on train companies constantly going on strike and a very small minority of train drivers going on strike. I think what we have seen from this government was a load of money going straight towards those same unions without the productivity changes that we would like to see. No adapting to the system, and actually my personal opinion on some of this legislation today is it is increasingly likely that automation and the loss of jobs will be a direct consequence of these very rigid trade union laws that are being forced onto more businesses, and I suspect that the only thing that will rise in this Parliament is unemployment. Because these strikes are costly, they're disruptive, and they're damaging to Britain. They ought to be a last resort. But this government's proposals will take us back to the 1970s, before I was born, when strikes were a political tool for division, damage and disruption. This is yet more evidence that Labour isn't on the side of working people or on serious economic growth, as their own impact assessment, even partial, tells us. Londoners will not thank this government if it results in yet more disruptive and longer rolling strikes that grind our city down even further than Mayor Khan has. Working people will not thank this government for empowering their trade unions to bring our country to a standstill, especially as we pick up the bill as they fill their pockets.
Yes, Frith.
Thank you, Madam Speaker, and I draw members' attention to my register of interests, which is if you listen, you'll hear, which is, my apologies, I draw members to my register of interests, which you will see I'm a proud member of the GMB, and that my donations included from entrepreneurs and business people alike, collectively sick of the 14 years of the party opposite in government. I will not take lessons from a party whose record after 14 years sees none of your contributions today defending anything of the achievements that you made in 14 years relating to this or anything to do with our economy. I will come to that. The party of F business, of striking NHS, of 60% furlough settlements for Manchester workers, of cash for COVID contracts, of inflation highs, of Liz Truss, of the mini-budget disaster, of zero growth, the collapse of infrastructure, public spending power disappearing, the state of our roads, prospects. It's for this reason my register of interest includes a combination of GMB membership and members and the workers that we represent, but also of the entrepreneurs that wanted rid of that lot over there. So I will make some progress and make some interventions. You've said plenty already. You weren't in for half. The honourable gentleman was in only halfway through the substantive half of the debate. Look, I'm proud to stand here on this side as someone who has founded and run a business for others and my own. 15 years ago, I made a commitment to be the voice of experience for good small businesses within the proud Labour movement we have now in government, not least to challenge the claim of the party opposite that they alone represent business interests. I am proudly pro-business, pro-worker, just as my government is too. Fixing the foundations of our economy means fixing the foundations of our employment. Just as this government is strengthening our economic base, it is now laying down stronger employment foundations. Running a business is hard work. It requires an initial leap of faith, the courage to embrace risk, the ability to adjust, the resilience to overcome failure, and the perseverance to celebrate success. The role of government is to improve life and living for everyone in this country. The role of good employment is exactly the same. Small businesses are at the heart of this effort. That is why this government is right to focus on skills, of value for money with public spending, opening up public sector commissioning to SMEs and challenger companies, and crucially, with this bill, making employment a more positive, rewarding experience. Insecure work leads to insecure living, and neither will improve life in Britain. We should highlight and support those employers who are already leading the way. Much of this legislation simply catches up to their high standards. The weight of responsibility that comes with creating somebody else's payslip cannot be overstated. It's humbling, sometimes worrying, never easy. It requires teamwork, the skills of others, but also leadership, sometimes lonely leadership. It means shouldering risk, sharing rewards, and that is why the government's ambition for growth is the right one. The focus must be on net growth, locking in certainty for those in work, but upholding rights for the many while fostering new opportunities that will expand our economy. I want to salute those businesses and entrepreneurs for whom much of this legislation emphasises the good practices they already uphold. In Bury, businesses like the Lamppost Cafe, where, declaration of interest, Madam Deputy Speaker, my own daughter works part-time, Life Store in Ramsbottom, Wax and Beans Record and Coffee Shop in Bury, Bloom, Avoira, MSL, Solution Providers, Ernell's Bakery, Warwick Aerospace Heat Treating and Hargreaves. These businesses, often family-run, are the backbone of Bury, and so they build the backbone of Britain. Rooted in their communities, providing stability, pride, good, honest work for an honest day's pay. Many of them stand ready to do more, to grow, invest and create more opportunities. I will.
gentleman for giving way. Could you tell us which of that fine list of businesses have said that they support this bill?
Deputy Speaker, I've had conversations with the vast majority of them. They support the general emphasis. Actually, if the honourable gentleman's been listening, the argument I am making is that much of this legislation, whether that's giving rights on day one, whether that's being fair-minded, whether that's making work pay, they are already doing this. And the point I am making as a fact, well, I have just named several. The most recent conversation I had was with MSL solution providers. And their challenges, their argument is around R&D tax credits, an argument I will make in due course. But this adoption or claim on being the voice of small business and entrepreneurship from the other side is misguided, it's misrepresentative, and frankly, it's out of date. Once we've laid these new employment foundations, we must support them in building their businesses further. In particular, for some, this means ensuring AI enhances and expands prospects and prosperity in the employment market and the wider economy. Lastly, I'm proud to have supported and highlight my support for extending bereavement leave to those who experience a miscarriage, a compassionate and essential measure which I proudly supported alongside my honourable friend, the member for Luton North. Madam Deputy Speaker, this bill is not just about a legislative process, it's about our values. It's about recognising that a thriving economy and a fair society must go hand in hand with tackling our inequalities. It is about ensuring that whether employer or employee, the foundation on which our employment is built ensures strength for all.
John Cooper.
Thank you, Madam Deputy Speaker. I rise as a former member of a trade union, and the harsh lessons I learned there are what concern me about this bill. As a low-paid journalist on a local paper, I had hoped the union would go into bat for me. Instead, it was more interested in Cuban socialism than collective bargaining, more concerned about traducing Mrs Thatcher's legacy than the tribulations of a junior reporter, more about funding the Labour Party than about supporting me and my newsroom colleagues. It's why I'm backing amendments such as 292, which seek to defuse what's been called a subscription trap, where inertia is used to allow political donations taken from members to tick up year in, year out. Is this the clean money of which the honourable member for Coventry South spoke? In the Business and Trade Committee, we've heard that good relations are possible between employers and trade unions. Of course they are. Not all union reps are agitators any more than all bosses are grasping exploiters of the workers. But stripping out existing protections, as this bill does, risks tilting the law too far in favour of the unions, making strikes more frequent and more damaging, thanks to things such as lower notice periods. And we know the unions are already restive. Just ask the Secretary of State for Scotland, unable to attend an event with, ironically enough, the Scottish Confederation of Business Industry in his own office because he would not cross a picket line, and who has had to cancel at least one other event as the pickets strike on. If a Cabinet Minister is already at the union's mercy, what chance the general public? We've heard about positive trade union benefits, but it's not all sunlit uplands. One rail union refuses to let bosses use email for rotas, insisting on fax machines, and I think I'm one of the few members here that remembers those. Another left passengers inconvenienced when they ordered members not to use a footbridge as it had a skim of snow no thicker than the icing on a cake on it. They must be licking their lips at clauses which remove previous thresholds for strike actions, such as the 50% turnout requirement and the 40% support requirement. Madam Deputy Speaker, I think the public will support amendments which would keep existing benchmarks as modest guardrails, not to crack down on unions, but to limit the damage hotheads might inflict. This skimpy bill, cobbled together within decent haste to meet Labour's first 100 days deadline, bears all the hallmarks of a thank you note from Labour to its union backers. If it passes, well, union's going to party like it's 1979. But the members opposite, pocketing supposedly pristine union donations, should have a care, because that 1979 winter of discontent saw the public lose patience with a Labour Prime Minister captured by the unions. History does not repeat precisely, Madam Deputy Speaker, but this does look awfully familiar.
Sarah Russell. Thank you, Madam Deputy Speaker. This afternoon, I want to talk about the points that I think actually we would probably agree on across this House in very large point. And that is that employment rights are quite useless without any sort of enforcement mechanism. I should first of all, though, mention that I'm a member of Community and Asdor trade unions and refer everyone to my register of interest. But to return to the point about enforcement, I am really pleased to see new section 122 of this bill. This reflects an increase in the time to bring employment tribunal claims from 3 months to 6 months. It is a result of extensive campaigning by Pregnant Then Screwed and other organisations, including the National AIDS Trust. They were very aware on behalf of their members of something that I used to see regularly as a solicitor, which is that a lot of people who have been treated very badly in their employment are actually so traumatised that they cannot come forward and make their claims within the 3-month time limit. And not only that, but actually that really reduces the potential time available for negotiation between former employees and their former employers, and that's not in the best interest of either employees or employers. So I think it's really good news for both parties that we're going to see this increase in the amount of time available to bring those claims. The other matter that I'm delighted with in this bill is the Fair Work Agency. We absolutely need there to be accountability for employers who are not paying the national minimum wage. They are few and far between, and those that are not doing it need to be properly monitored and enforced against to create a fair playing field for all companies. I am sure that the party opposite would completely agree with me that the national minimum wage is a very fundamental part of our society and that everyone should be paying it. The other matter that I want to draw attention to is the Adult Social Care Negotiating Body. In my constituency of Congleton, we have really significant numbers of people who need adult social care, and having a stable workforce is so important to that. Lastly, I'd just like to speak about the attitudes towards trade unions that I have seen on the benches opposite today. When I have worked as a solicitor advising trade union members some time ago, what was very clear to me was that actually people really needed the advice that they were getting via their trade union, but also that their trade unions would not continue to back them with that advice if they didn't have claims with reasonable prospects of success. And that meant that disputes could be settled and that was in the best interests of both their employer and employee. Yes, I will.
Thank you. I thank the Honourable Lady for giving way. I think she misrepresents possibly the intent on this side of the House, which is that we are not anti-trade union, but what we are is anti the drafting of this bill. And I think it's very important to make a clear distinction between the two.
I would thank the Honourable Lady for her point. I think it's a very difficult distinction to make, to say that you are pro-trade union but anti things that make it easier for trade unions to effectively represent workers.
Yeah, 100%.
But to return to my point, access to trade unions means access to good quality advice. Yeah. It means quicker resolution of disputes and a reduction in unrepresented litigants in person, which in my experience can make life genuinely very difficult for well-meaning employers. Every single thing in this Act will be good for workers, but it is also good for employers, and I'm very pleased to vote for it later today. Jane Kirkham.
Deputy Speaker, I refer to my register of interests and declare my Unison membership. Although I'm also actually an ex-solicitor, I'm going to address the government amendments relating to enforcement rather than trade union rights. We have a large demand for social care in Cornwall, as the Honourable Member also did. Our population tends to an older demographic, and with many people leaving friends and family to retire to Cornwall, the availability of care is very important. Our social care system's close to breaking point, the combination of years of underfunding and a fragmented privatised system. Skilled care workers are chronically underpaid for what they do, often at minimum wage, and we struggle to get and retain care workers. This bill has many provisions in it that will help strengthen sick pay, parental leave, protection from unfair dismissal from day one, improving family-friendly rights, flexible working, measures to tackle those zero-hour contracts, including now for agency workers and umbrella companies as well as direct employees, and strengthening redundancy rights. But the bill also specifically gives that respect and recognition for social care workers through a fair pay agreement and the reinstatement of the school support staff negotiating body. This will be a game changer for those low-paid workers, mostly women, who work in care and schools. I will give way.
I'm grateful to the Honourable Member for giving way. She'll be aware that next week there will be a debate on the National Insurance Contribution Bill, where there'll be a debate about whether or not health and social care providers should be excluded from National Insurance Contribution. Would she care to comment on whether or not those benches will support that amendment that's coming down from the House of Lords?
I thank the Honourable Member for her intervention, and of course government funding, local government funding will be increasing to take that into account, and funding for adult social care is rising and will rise further in the next 3-year settlement under this government. To return to my speech, in Cornwall we've also seen the rise of care workers coming from other countries to work on sponsorship visa schemes. Often these workers are in a very financially precarious situation, which increases their dependency. Some have been charged by their employers for induction, travel or training. In some cases, workers receive a salary below minimum wage to make up the costs of their flights to the UK. I will be.
Thank you, Madam Deputy Speaker, and I refer colleagues to my register on the entry in the Register of Members' Interest. My honourable friend is making an excellent speech about the situation in her own county. Does she agree with me that this is indeed a national problem for all of us in our constituents? It certainly is the case in Berkshire and in Reading in particular that we need better pay for care workers, more understanding about the pressures on them in their very valuable work.
Jacob.
I do agree with the Honourable Member. This is something that crosses the entire country. And I know that Unison, for example, do have a campaign particularly about migrant care workers. So yes, I do agree this is a national issue. In Cornwall, those care workers are often being given the early morning and late evening shifts with no flexibility. Some are sitting on benches stranded in Cornish villages where buses don't pass through, waiting from their morning shift to their first evening shift. Many health and social care workers on sponsorship visas are afraid to raise concerns about their employment and living conditions for fear of losing their employer's sponsorship. Employers, in turn, can be aware of this, and some even use it as an explicit threat. So that's where I come to the enforcement provisions in this bill. Enforcement of statutory pay and employment rights is poor in the social care sector. Pay enforcement relies on individual workers reporting breaches. HMRC investigate fewer than 1% of care providers per year. International workers and those from minority ethnic backgrounds are particularly vulnerable. For individual rights to become a reality, a collective voice in the workplace and effective enforcement are key. The Law Society reports that the backlog in employment tribunal cases stands at 44,000, which is 18% higher than it was in 2023. This backlog needs clearing and investment made in employment tribunals. The new Fair Work Agency will have a crucial role to play in reducing the burden on the employment tribunal system by providing a focal point for advice on enforcement under Government Amendment 208, enabling the disclosure of information under 212 and taking on some of those enforcement powers under Government New Clauses 57 and 58 on behalf of those workers. Those powers could really help low-paid or migrant workers who don't have access to funds or union representation to enforce their rights or fear dismissal if they do so. Government Amendment 249 will allow the Fair Work Agency to investigate and combat fraud and exploitative employers, so tackling the kind of modern slavery we've seen recently of international workers in the care industry. And Government New Clause 60 will also give the Fair Work Agency the power to recover the costs of enforcement, which will help with the funding of the system. However, real investment will need to be made into enforcement for the new powers to have teeth, with a timeline, resourcing and fast-track procedure for the new Fair Work Agency. And I welcome confirmation of the Government's commitment to this.
Can I just give members a brief reminder that we are today talking to the new clauses and amendments on trade unions and industrial action, enforcement of labour market legislations, miscellaneous and general provisions specifically. John McDonnell.
Thank you, Madam Deputy. Can I declare my entry in the Register of Interests? Can I also say I'm dealing with amendments, 2 new clauses, 8 and 9, with regard to the recognition of the POA's right to strike. So therefore I can also declare that I'm honorary life member of the POA. Honorary, there's no financial relationship, and I'm assured I wouldn't even get a south-facing cell or extra pillow. What these amendments do is try to restore the fundamental right of prison officers to take industrial action of its various forms. The union existed for 90 years and as organised as a trade union has never taken any form of industrial action which has endangered the prisoners they were to care for, or the other staff, or the wider community, and had that long history. And it was a history of industrial relations climate for all that period in which negotiations took place and disputes were resolved. But then in 1994, the then Conservative government, under its Criminal Justice Act, made it a crime to induce any prison officer to take strike action or even to work to rule. So the trade union basically was told very clearly that this would be a criminal act, and any trade union officer organising, even just to work to rule, could be prosecuted. What the government then did, and this is why I think people became extremely cynical at the time, is that they then planned the increases in pension age, retirement age, extensive salary cuts, and also cuts in staff numbers. And there was no way the union could fight back in any form to protect their members. At one point, some members may recall who were about at the time, the POA faced high fines, the 6-figure fines in the High Court in 2019. And then when they took action on health and safety grounds, convening meetings of their members, they were threatened with legal action, and the union leaders were threatened with imprisonment. Ironically, it would have been interesting to ask the question who would lock them up, but that's another question altogether. When the police had their right to strike taken away from them, they were given it's almost like a covenant, they were given very specific commitments around how they would be protected on pay and pensions and conditions of work. That was never offered to the POA. There was never any negotiation like that, where at least in return for the loss of that right, they would be given some security. They never were. So what the POA has done is they took the government to the European Court of Human Rights in 2024, and the case was accepted. And the court then urged the government to engage with the union in good faith over what remedies that would be available to them. The government at the moment the government then refused to engage and now is still not engaging. So one of the reasons for putting these new clauses down is to urge the government to start engaging with the union around this particular issue. All the union is asking for is to be treated like any other workers and for the government to engage. In Scotland, 10 years ago, the right to strike was restored, and there's been no strike action since. But what it's done, it's created an industrial relations climate that's conducive to working together, not to conflict, but to negotiate problems out. And actually, I think that's as a result of both sides knowing that there's that obviously alternative, if necessary, to be used, which is to take parts of industrial action. And often the industrial action, as most people know, in public services is not a strike. It's usually a work to rule to start the negotiations off. And every union, I've been a member of a trade union for 50 years, I've been a trade union officer and lay official, etc. Every union I've known where there's any form of industrial action that in any way involves a public service always puts in place negotiated arrangements to protect the people that they're serving. And that isn't just life and limb protection, it's often ensuring that there's a standard of service that's still acceptable to people. So yes, I'm urging the Minister to get back round the table with the POA. Can I just say that there was a debate in the committee on this, and it angered people, and it angered me. I've gone over that debate, and it showed a disrespect, a shameful disrespect for prison officers themselves, an ignorance of the role that they play and the working environment that they work in. There was references to screws and guards and things like this, and about how somehow, if this right was restored, the union would allow the prisoners to run amok and put the whole community at risk. That's never the case. That's never been the case and never would be the case. And there's a lack of understanding about what these workers are putting up with at the moment. As many of you know, there's overcrowding. Many members, honourable members know, there's overcrowding. Prison officers are dealing with prisoners with huge mental health issues, drug problems and health problems overall. And the levels of violence in prisons at the moment is at record levels, and prison officers are being almost on a daily basis injured as a result of assaults. So I have to say the disrespect that was demonstrated at the committee actually was part and parcel of demoralising even more of our workers within those key roles. So I just ask the Minister to re-engage. Just get back round the negotiating table and recognise that this is an issue that will not go away, because these members want the basic trade union rights back again, and if necessary they will go back before the European courts, and I believe they'll win, and I think unnecessarily we'll go through another period where workers continue the demoralisation because of the lack of respect that the people have for their basic trade union rights. And at the moment we're suffering real problems in terms of recruitment and retention. So I urge the government just to take that one step back to the negotiating table with the POA.
Becky Gittins.
Thank you, Speaker. I rise today in support of new clause 57 and new clause 58 tabled by this government. From the outset, I refer members to my entry in the Register of Members' Financial Interests and my proud trade union membership. Madam Deputy Speaker, I would ask the opposition to consider their comments today in what has proved to be a very ideologically driven debate on their part. I feel somewhat as if I've been transported back in time to a previous reforming Labour government's last upgrade to employment rights, the minimum wage debate. Reminiscent of this is the fear-mongering about productivity, growth and unemployment that we've seen this afternoon. We also have seen some crossover in some of the personnel who were part of both Conservative oppositions. The member currently for Chingford and Woodford Green, while he was the then Conservative Shadow Secretary of State for Work and Pensions, said that the minimum wage will negatively affect not hundreds of thousands but millions of people. Now, Madam Deputy Speaker, unless the opposition has since developed a policy to repeal the national minimum wage, and let's face it, under their current leadership, anything is possible, I must say to them that progress is coming. Work that pays, dignity and job security. And I would invite them to get on board with the upgrade to rights at work now, rather than spending the coming decades pretending that they were on board in the first place. I will give way.
I thank her for giving way. She recalled that in 2017, when the Conservative Party announced the employment bill that was never produced, they said that it would represent the biggest upgrade of workers' rights by any Conservative government ever. Would she care to speculate on why they set their ambitions so low?
I thank my honourable friend for the question, and I think it's been made by some of the comments on the opposition benches today, been made very clear to the public what they think about people's rights at work. Now, Madam Deputy Speaker, I'll give way.
Thank the honourable lady for giving way. She's making a very passionate and inspiring speech, and she spoke passionately about the national minimum wage. I wonder, was she aware that just last year the leader of the Scottish Labour Party admitted admitted that his own family business were not paying the living wage to members of staff. Does she think that's rank hypocrisy?
I thank the honourable member for his question. I think that everybody should be on board with the national minimum wage and also the living wage, and I hope we can encourage all members of all parties to get on board, and I'm very, very pleased to hear that commitment and concern from the Reform Party. Unexpected, but I respect it. Madam Deputy Speaker, I welcome this legislation at second reading as a central tenet of this government's policy to put working people at the heart of our economy and to make work pay. I am delighted to see this bill return to the Chamber and pay tribute to those that served on the Public Bill Committee. This bill modernises the UK's outdated employment laws, bringing in over 30 much-needed and welcomed reforms, including day one rights of employment, banning exploitative zero-hours contracts and abolishing fire and rehire, establishing bereavement leave, increasing protections from sexual harassment, introducing equality menopause action plans and strengthening rights for pregnant workers, and establishing the Fair Work Agency. As part of the scrutiny process, I am also pleased to see that the Government has brought forward amendments to strengthen protections of low-paid workers, including through statutory sick pay. What the totality of these measures will mean in real terms is that 1 million people on zero-hours contracts will benefit from the guaranteed hours policy. 9 million people who have been with their employer for less than 2 years will benefit from day one unfair dismissal policy. And because of the Fair Work Agency, holiday pay will be enforced for the very first time. Today sets out the strengthening of the Fair Work Agency. New Clause 57 will enable the Fair Work Agency to bring proceedings against a non-compliant employer in an employment tribunal, in place of the worker. New Clause 58 enables the provision of legal advice or representation for those that may have become party to civil proceedings related to employment or trade union law. Whilst it's certainly the case that many employers, the vast majority in fact, including hundreds in Clwyd East and across the country, will obey the law, there are still those that sadly do not. As the Citizens Advice Bureau report states, higher paid workers are 50% more likely to bring an employment tribunal claim compared to lower paid individuals, despite lower paid individuals being more likely to have their rights violated. As Unison points out, leaving the burden of challenging workplace injustice to individual workers seeing redress at tribunal compounds inequalities of power within the UK labour market. The Low Pay Commission's figures highlight some of the key reasons for the implementation of these important measures. For instance, we know 20% of workers paid less than minimum wage in 2023 and nearly 1 million workers who didn't get paid any holiday pay. The agency will bring together existing state enforcement functions and will be a single place where workers and employers can turn for help. I'm also pleased that the agency will aim to resolve the issues upstream by supporting employers that want to comply. I understand from evidence gathered during committee that there was considerable support for a single enforcement body in place of what is currently quite a fractured system. In terms of accountability, the bill requires an annual report on the Fair Work Agency's enforcement actions and will allow Parliament to monitor progress in protecting workers' rights. Madam Deputy Speaker, I am encouraged to hear that the approach of the Fair Work Agency in producing its strategy will consult with an advisory board made up of trade unions, businesses and independent experts. It is vital that we continue our collaborative approach in developing employment legislation and policy that is pro-business, pro-worker and ultimately pro-growth. I welcome both of these new clauses, as I welcome the bill as a whole. It's an important part of this government strategy to move our economy forward, to improve work security and ensure greater productivity. Thank you.
Douglas McAllister.
Thank you, Madam Deputy Speaker. And in speaking in support of this Government's Employment Rights Bill, I wish to declare that I am a member of Unison. Today, this bill and government amendments will deliver real-life improvements for working people across my constituency of West Dunbartonshire and across Scotland. Key amendments will strengthen protection for the lowest paid workers in my constituency, extend protections from exploitative zero-hour contracts and boost the voice of working people in the workplace, from strengthening statutory sick pay 80% from first day of sickness, extending sick pay to 1.3 million of the lowest earners across the country, and, of course, greater protection from unfair dismissal. 9 million people benefiting from day one protection. This is the real change we promised to deliver, benefiting real people, people in my constituency of Western Bartonshire, working in public services, frontline staff, the service industries, essential utility companies, social care, transport, health. The days of exploitation are now over. The Labour Party doing what we do best and what we will always do, protecting working people, promoting decent pay and work and delivering meaningful change for so many, putting power in the hands of working people. This government's commitment to growing the economy will be built on rebalancing the rights at work and raising living standards in every part of this country, because the two are interwoven. Today's amendments from the government will do just that, boosting enforcement of rights, giving the new Fair Work Agency the power to bring civil proceedings against non-compliant employers who seek to underpay staff. 1 in 5 workers in 2023 were paid less than the minimum wage. That will stop. Almost 1 million workers in this country didn't receive holiday pay in 2023. That will stop. Today's amendments will level the playing field. Digital access to employment agreements, allowing independent unions to apply for recognition and stopping the practices of employer lockouts. A 20 working day window for employers and unions to negotiate access. A new right for unions to access the workplace. This has the potential to be transformational, giving workers a fair voice to help improve their pay and conditions. It's time to turn the page from the combative and unproductive approach adopted by the past government and to modernise the industrial relations framework. This bill and amendment supports a much-needed reset of industrial relations across Great Britain. This government has a clear mandate to deliver real change that working people in my constituency of Western Bartonshire can see and feel. That change can't come soon enough. The Employment Rights Bill is the crucial first step on that path. It is a first step, but it's the biggest uplift in workers' rights in a generation, and I am proud to vote and support for it today.
Turner.
Much, Madam Deputy Speaker. I'm grateful to be called twice over the report stage debate, and as is customary, I draw attention to my declarations in the Register of Interests, my membership of Unite, and I'm chair of the GMB Parliamentary Group. Madam Deputy Speaker, I start by making comments that had not been planned at the beginning of this debate, but much has been heard about registers of interests. And as the Shadow Minister, who's in his place, said at the end of the Bills Committee, Labour members have been, in his words, assiduous in drawing attention to their membership of trade unions and their registers in the declarations of interests. But I believe that the Honourable Member for Meriden and Solihull East was the first Conservative member to draw attention to his own donations without being challenged first. Much of the tone of this debate has focused not on the substance of the bill in front of us, but on ascribed motivations, which I believe has been demeaning to the standards and courtesies expected of this House. Now, Madam Deputy Speaker, there's much to welcome in the government amendments in front of us today, and I wish to concentrate my remarks on New Clause 40 and New Schedule 2. In respect of political fund ballots, the 10-year requirement dates to the Trade Union Act 1984. The requirement does not apply to any political funds that may be maintained by employers' associations, nor does a successful ballot in any way infringe upon a trade union member's right to withdraw payments from the political fund at any time. So I think we can be confident about that policy's intention. It was to tie up trade union time and resources, and in that respect it was successful. These ballots are a massive abstraction of resources that get in the way of trade union and trade union members' core business of representing people at work. In 40 years, not one union members have voted to discontinue a political fund. Trade unions are democratic organisations. If there is discontent within a union at political fund expenditure, then any member is entitled to inspect the accounts, and that expenditure can be stopped in whole or in part through existing democratic structures. There is, I think, a contradiction when this House, which is a representative democratic institution, may seek to instruct other organisations that they must make decisions by referendum. And to those who have suggested that trade union political expenditure is somehow illegitimate, I would just like to remind members that trade union political fund expenditure is not synonymous with party political donations. In fact, many important campaigns which have won cross-party support in this place were only made possible because of that trade union political fund expenditure. And I draw attention to one campaign which I was proud to be associated with, which was the Protect the Protectors campaign, which resulted, starting with the campaigning work of GMB members and Unison members in the ambulance service, and resulted in the Assaults Against Emergency Workers Protection Act. If the measures which have been put forward at different stages in this process were successful in restricting that political fund activity, then it would be harder to deliver that legislative change on behalf of working people in this place. Now, much has been said, and I do not wish to duplicate, but I wish to say a few words about the situation at Amazon in Coventry. Much trade union work in the private sector in recent years has been focused on the warehousing and logistics sector, where increasingly intensive workloads, workers' employment terminated on the basis of unclear and unaccountable target setting, and high rates of musculoskeletal injuries that are contributing to the high rate of our people out of work in the wider economy, has been a focus for that trade union activity. Now, when the GMB, in response to approaches from its members, initially contacted Amazon to seek voluntary recognition at that site in December 2022, the company reported that there were 1,400 people working at the site, and the company refused to engage meaningfully with the union or attend talks at ACAS to resolve the situation. As has been said, in the space of just a few months, the number of people at the site was increased dramatically by some 93%. Some of them were temporary workers transferred from other sites. It has been reported that others were new workers on student visas who were worried about the potential implications for their studying and immigration status if union recognition was voted for. As a consequence of that increase, the union could not still meet the 10% membership threshold, but it could not have meant the requirement that 40% of the bargaining group would be likely to support recognition. New Schedule 2 remedies this flaw by freezing the bargaining unit from the start of the application. Similarly, the schedule bars the use of unfair practices from the start of that process. This addresses a loophole in the current statutory code of practice, which was exploited to the full in Coventry. The union described a culture of fear born of intimidatory tactics and a lack of equality of access, contrary to the principles that this House has already endorsed. The recognition ballot failed, as we've heard, by just 29 votes, and I would like to pay tribute to the GMB officers and, above all, members who led that campaign. They came so close in the face of a concerted union-busting campaign. As one Amazon worker said, "I don't want Jeff Bezos' boat, I definitely don't want his rocket, I just want to live." Now, the opposition argued in committee that we should not legislate in response to individual cases, but I disagree. Once it has been proven that a system can be exploited, then more will follow. Amazon's actions at Coventry are clearly contrary to the intention of the House of Commons when it established a statutory recognition regime 26 years ago. So freezing that bargaining unit is incredibly important, as is the extension of the code of practice. Now, I wish I could say in the time that's available more about the trade union right of access, which builds upon successful international systems, particularly in Australia, where over the last 20 years it has become an accepted and constructive part of their industrial relations framework and has survived and indeed been enhanced under multiple changes of governing party. The digital right of access, which is included in the amendments brought forward today, is important, particularly for those employers that do not have a traditional physical workplace. It is important that the digital right of access must not become the default when applications are made, and I'm sure that ministers will bear that in mind as these measures are implemented. But if I may close at what may be the last debate that backbenchers can contribute on this legislation, it is part of the reason that we come to this place to provide more freedom, more comfort at times of hardship, more protection against abuse to our constituents, and that is as true at work as it is everywhere else. Of course, there will always be other causes, other measures, other changes that we individually would like to see. But for me, this bill and the changes, improvements we will make to it tonight are the reason our constituents sent us here to this place. It has been said that this legislation represents the biggest advance of workers' rights in a generation. I think it's perhaps the biggest step forward since the Trade Disputes Act of 1906. What we will do tonight is truly historic, and I will be proud to join the lobbies to vote it through.
Yeah. Joe White.
Thank you, Madam Deputy Speaker. I wish to refer members to my declaration of interest, which clearly states my positive relationship with the trade union movement. I'm a member of Community and the GMB. And that's where I want to begin my contribution to this debate. My father, a proud USDOR member, recruited me to his union the very first day that I had a proper job, aged 16, drawing a real wage with a pay packet and a pay slip. I had stepped up into the grown-up world, and joining a union was part of my graduation. I was brought up to believe that a union has got your back and can help you with issues like unfair dismissal, discrimination, harassment or bullying. And as an MP, when I'm approached by a constituent with a problem at work, my first question is, are you a member of a trade union? In Basset Law, good companies and organisations like Cargill, Schutz, Cinch, Siriato, Autism East Midlands and Basset Law Hospital have good partnerships with unions like the GMB, and I welcome that. Also, as a small businesswoman, I served for 10 years on the national executive of the long-ago merged MSF. And this is where I reinforce my values and belief that a trade union is a force for good in the workplace, where partnership working with the employer serves to increase productivity, pride and shared understanding. Such partnerships mean that many of the key employment measures in the Employment Rights Bill have already been adopted by many major employers who regard good employee relations a key element for their competitive success in the markets they operate in. When people go to work and they have no certainty over the hours they work or what their weekly income will be, it's unfair. When people go to work with the fear that they may be sacked tomorrow for no reason, it's unfair. When people are paid below the minimum wage for a day's work, it's unfair. And when people are ill and they face 3 days without pay, it's unfair. This bill is about putting fairness back into work and putting pride into our workplaces. We need to end the zero-hour contracts, end the trickery of high-end refire, deliver one-day protection from unfair dismissal and extend rights to sick pay to 1.3 million people. Of course.
I thank the Honourable Lady for giving way. I'm also a member of a union, the British Medical Association, and have found them useful as a union representing me in the past. I can see the benefit of unions. However, I am concerned that the measures that the Honourable Lady is talking about in relation to first day sick pay, for example, could make it more difficult for those with disability to get a job, particularly with the changes to zero hours contract as well. And indeed, talking to a local businessman in my constituency about a gentleman he employs with a disability that comes and goes and makes it very difficult for him to work for long periods at a time, he says he simply won't be able to continue to employ him once this legislation comes into force.
Thank you for your intervention. That's what good, strong trade union partnership is about. It's about ensuring a worker has the interventions that they need in order to be able to work. So that's why I'm supporting the benefits bill that's coming in the future, because that will ensure that workplaces are open and accessible for people with disabilities. It's so important that people have the right to work and the capacity to work when they need to. So what I'm saying, that this bill is backed by my constituents who want to work hard but also want fairness in the workplace. Tonight, I will be voting for strengthening rights at work for millions of British people. We can all stand up and be counted to support our constituents who deserve fairness and justice at work. And to the Reform MPs who are no longer here, supporting the status quo is a betrayal for millions of British workers. Yeah. We all have constituents who need better workplace rights, and this is our chance to deliver change.
Yeah. Thank you, Speaker. For the record, I am a member of United Union, but today I rise to make my remarks from the perspective of a business owner and employer, and in response to comments made by members opposite around small and medium-sized businesses, although I see they've now wandered off. So these are personal comments, a personal perspective, but I know many businesses, large and small, that share this point of view. Before coming to this place, I've been running businesses of various shapes and sizes for well over 20 years. I did my MBA at Manchester Business School. I've started and led several businesses and served on the board of many others, so I've kind of been about a bit. Throughout this time, it's always been clear in my mind that whatever the business, the absolute critical success factor is always the skills, drive and quality of the people that the business employs or contracts. To succeed, any business must attract the best possible people. This is why I've always felt the selection and recruitment process was my key role in any organisation that I led. So we'll always argue that great businesses, by which I mean those with sustained success, will always be good employers. And when I look at the measures in this bill, all I see are the things that good employers are already doing. We know that support for employees when they have children pays off in the long term. We know that giving employees job security increases their commitment and productivity. We support our people when they are sick, and we know that taking holidays is vital to maintain performance. We don't unfairly dismiss whether someone has been with us for one day or for many years. We do have rigorous recruitment processes and make clear that employees must show they meet requirements for a job during the probationary period. We pay as well as we can, knowing that employers who feel valued will deliver for our businesses. Up until now, good employers have always felt the risk of being undercut by unscrupulous and short-term disruptors looking to make a quick buck. This is a real and serious issue. I've experienced it in business, and many other business owners have raised it with me. Businesses doing the right thing should not be disadvantaged, yet weak, outdated employment legislation has left them exposed. This bill levels the playing field. Good employers can keep on doing what they do, knowing that their competitors can no longer undercut them by, for instance, employing the majority of their staff on zero-hour contracts, not giving holiday pay, firing and rehiring, or just underpaying. This bill is good for good businesses and good for workers. It's good for growth and good for society. It will put more money in people's pockets and deliver real and tangible benefits for working people, and I'm very pleased to support it.
Sonia Kumar.
Thank you, Madam Deputy Speaker. I draw my attention to the Register of Interest, which includes G&B, Unison and the Chartered Society of Physiotherapy. When I spoke in this House during the second reading of the bill, I welcomed the advancements it would make on statutory sick pay, on maternity, paternity, protections around pregnancy and the values of fairness in the bill. I now support new clause 44, 47 and 48. It's only right that if someone has done their fair day's work, that business, and if a business fails to pay them, that the Secretary of State should have the authority to give notice of underpayment. No one in Britain should go home from an honest day's work and out of pocket and worried about paying their bills. And I also welcome the Secretary of State's interventions on imposing financial penalties on businesses who make underpayments. I believe poor practice in the workplace should be called out and those responsible should be held accountable. However, we also need adequate resourced Fair Work Agency. Therefore, I support the Business and Trade Committee's Chair's new clause 82. The agency should be agile enough to tackle issues upstream by supporting businesses who want to comply with the law, as well as having enough resources to tackle meaningful, non-compliant businesses. On the Business and Trade Committee, we heard from several businesses, some who were great employers and others who were unable to justify their malpractice, with evidence of modern-day slavery in their supply chains. We can't have companies getting away with poor practice where workers can't use the toilet, not entitled to their breaks, or failure to get their fair pay. Transparency, accountability and enforcement is key. But we must remember that most businesses do their best by their workers, and I've witnessed this. Since their second reading, I've met with businesses owners in several sectors, from steel workers, scaffolders, from restaurant owners to retail. And during my visits and roundtables of the constituency of Dudley, both workers and employers often tell me they want the same thing. They both want stability. Stability to grow and have the fiscal responsible government who cares about them and their future. Stability is not a zero-sum game. Research shows that businesses look after their employees, they create a more loyal, productive workforce, in turn strengthening businesses and helping them grow the economy. In 2023, Deloitte Digital Research found that fostering trust, opportunities for growth and employee well-being are key factors to increase workforce retention and satisfaction. To reassure businesses, we know that the implementations of this bill will be in phases. This approach promises to allow step-by-step upskilling of HR professionals, up-to-date employment practices to be taken one step at a time that will not be expected to be employed until 2026. Therefore, I ask the Minister to provide a roadmap outlining details of future consultations within the 2-year timeline to help guide businesses owners to provide stability for businesses. A roadmap would undoubtedly help ease growing pains, allowing small businesses time to plan the necessary administration, upskilling and the ability to resource the Fair Work Agency. Both workers and business in Dudley would benefit greatly from this stability, and I wholeheartedly support this bill.
Steve Young.
Thank you, Madam Deputy Speaker, and I rise to support this bill, but in particular this afternoon to support Government New Schedule 2. And at the same time, I must draw the House's attention to my entry in the Register of Members' financial interests and to my membership of both the GMB and Unite trade unions. But I should also make the House clear about my employment history, both as a Chief Executive Officer and a Managing Director of companies in the United States, in the UK and in Israel, and also my record as a company founder and employer. I'm also very proud of having been a union member since my first day at work when I joined what was the Association of Scientific, Technical and Managerial Staff. And I think I can probably add a few years to the membership of the Honourable Member for Derby South, but I've got a few more years to go before I catch up with the Right Honourable Member for Hayes and Harlington. I'm also very proud to be supporting this bill and the amendments tabled by the government so that we can deliver reforms that are rightly pro-business and pro-worker. It will also put more money in people's pockets and deliver real-life improvements that will be felt by working people. Key amendments tabled will strengthen protections for the lowest paid workers, extend protections from exploitative zero-hours contracts and boost the voice of working people in my constituency of Mansfield. However, I want to particularly welcome that amendment of Government New Schedule 2, which will update frameworks for trade unions, reflect modern work practices and rebalance industrial relations. Part of this amendment will ensure that the size of a workplace bargaining unit will be frozen and cannot be increased during the recognition process. A recent example of this, where the amendment would have supported workers, was at Amazon, when my union, the GMB, first applied for statutory recognition there. Amazon had reported that they had 1,400 employees working at the site and refused to have any discussion on trade union recognition. Amazon workers were truly facing a David versus Goliath fight, having to prove that they have at least 40% support in the workplace for union recognition. The bill we are debating today and the amendment will vastly simplify this. The amendment frees us the bargaining unit at the point of application. And I think that we want to be able to bring that good practice and good employers to our constituencies. And Mr. Speaker, Madam Deputy Speaker, while I'd happily speak further in support of so many of these amendments, yes, I'll give way.
For giving way. In 2023, BH Live, a company based in my constituency, were named for not paying 130 workers the national minimum wage, 130 of the lowest paid workers in my constituency. Ultimately, they did make payment, but would my honourable friend agree with me that that is wrong, that nobody should be paid less than the national minimum wage, and that with the introduction of the new Fair Work Agency, we're going to be able to right wrongs like that?
Absolutely, with the honourable member, and I think he also spells out why enforcement is so important. And just to conclude, Madam Deputy Speaker, I'd happily support so many of the amendments today, but I'm acutely aware that we're at the end of this debate. However, in concluding, I do want to... Yes.
Coming to his exciting peroration, I just wanted to say this. I think he's absolutely right about the feckless behaviour of corporate businesses who disregard the interests of their workers, and I share his view, by the way, about trade unions. But does he recognise there's a world of difference between the burdens we place on those organisations who can happily deal with them and the effect that some of these bills, I think unintentionally perhaps, will have on the very small businesses of the kind I imagine he started, and at least at the beginning they were small, and the fear that that's caused amongst those small and micro businesses. There is a real distinction here, isn't there, between those heartless corporates, those hard-working SMEs in his constituency and mine.
The honourable member for his intervention, and of course, as a business founder, a small business and someone who's grown a business, I do recognise the need for balance, and I am grateful for him raising that. But in my concluding remarks, I do want to put on record how proud I am of my unions, the GMB and Unite, for the work that they have done, working with this government to help deliver this groundbreaking legislation, and I'll therefore be voting with pride to support this bill in the voting lobby later today.
Minister, Justin Madders.
Thank you, Madam Deputy Speaker. It's been an excellent debate again. I think there's quite a few misconceptions we might have to deal with, but I'm conscious we will need to move on to third reading. So apologies if I don't address every single contribution today, but I will start with that of the Chair of the Select Committee, my right honourable friend, the member for Birmingham, Hodge Hill and Solihull North, and his amendment, New Clause 82. The bill already requires the Secretary of State to produce an annual report for employment rights enforcement, as well as an enforcement strategy every 3 years. Both documents will also be laid before Parliament, allowing for parliamentary scrutiny. We are committed to giving the Fair Work Agency the resources it needs to do its job effectively. And I agree with him when he said the number of prosecutions for minimum wage violations has been pitifully small in recent years, and we should never tolerate law breakers in the business world. We should ensure that responsible and good performing businesses are never allowed to be undercut by minimum wage violations. Turning to his amendment 282, this would seek to include digital means of communication with workers into unions' rights of access into workplaces. And I appreciate the good intentions with this amendment, but the government is already committed to modernising working practices and moving away from a reliance on ad hoc access arrangements. We recognise the importance of providing for a digital right of access in addition to the physical access that the bill already provides. That is why we have amended the bill to expand access rights, allowing for access agreements to include communication with workers other than by means of physical access into a workplace, such as digital means. My honourable friend, the member for Middlesbrough and Thornaby East, talked about procurement and his new clause which would amend the Procurement Act 2023 to place a duty on the Secretary of State to ensure that any contract entered into by either a government department, an executive agency of government, a non-departmental public body or a non-ministerial department must comply with certain requirements relating to the recognition of trade unions. We do recognise that recognition of trade unions for collective bargaining was an important feature of the previous two-tier code on workforce matters. This bill contains powers to reinstate and strengthen the code by way of regulations and a statutory code. So I can assure the House the Government is committed to strengthening trade union recognition and collective bargaining rights. I will now turn to new clause 77 in the name of the Honourable Member for Dundee Central. This would result in a change to the Scotland Act 1998 by removing employment law from the list of reserved matters, thereby bringing it within the competence of the Scottish Parliament. And whilst the Honourable Member's perseverance on this issue is not unnoticed, it will come as no surprise to him, if he were here, that the Government has no intention of devolving employment law to the Scottish Parliament. Previous Scotland Acts have already created one of the most powerful devolved parliaments in the world. And of course, when there were considerably more SNP members here during the last Parliament, there was a 10-minute rule bill on this very subject, and the SNP couldn't even get a majority of its own members to support it. So why on earth would we support it now? I don't know, Madam Deputy Speaker. So I'll turn now to the amendments from the Right Honourable Member for Hayes and Harlington in respect of prison officers' right to strike, and I thank him for his persistence and active engagement on behalf of prison officers. As he said, prison officers are prevented from taking industrial action under current legislation. Their pay is governed by the Independent Prison Service Pay Review Body process, which acts as a compensatory mechanism for that restriction. There is limited contingency to deal with industrial action, and during such incidents, reliance is on a narrow pool of operational managers with some potential for very limited support from the police and army in limited circumstances. This does create operational risks and is not sustainable for any period of time. And my right honourable friend did refer to the debate in Bill Committee on this and some of what he classed as disrespect to prison officers during that debate. Can I just put on record that certainly there was no disrespect shown from this side of the House. We absolutely value and respect the work that prison officers do, and I know that my honourable friend will continue to pursue this matter, and I would suggest that he contacts the Department for Justice, who have the remit for this issue, and I hope will be able to engage on the matter in future. Turning now to some of the Liberal Democrat amendments, the Honourable Member for St Albans spoke to new clause 19, which would provide the power for the Secretary of State to set out and define in regulations the professional bodies that could represent employees in disciplinary and grievance meetings. It's unclear to us where the demand for this would come from, and I would expect that this would benefit some businesses who have raised this prospect with successive governments. But what is clear is that expanding the types of organisations that could be involved in representing workers at discipline and grievance meetings could actually lead to hearings requiring legal representation for both the worker and the employer. This would actually increase the cost of holding a hearing, escalate matters and potentially decrease the chance of an amicable resolution as both parties become entrenched in a dispute. We believe that trade unions are best placed to represent employees in disciplinary and grievance hearings in the workplace, and the statutory provisions are already in place to enable them to do that. The Honourable Member for St Albans also tabled amendment new clause 111 in relation to legal aid for employment disputes. It's very clear, and I'm absolutely committed to ensuring that workers are able to enforce their employment rights, and we are working closely with the Ministry and Justice to ensure this happens, and looking closely at what further improvements that we can make in the way that ACAS and employment tribunals operate. A key benefit of moving enforcement to the Fair Work Agency is that it will make it easier and quicker for workers to get justice without the need for additional legal representation or legal aid. So I hope that gives us some assurance that we are looking seriously at that issue. She also moved new clause 110, which would have the effect of requiring the Secretary of State to publish a review on the impact of Part 4 of this bill on SMEs within 3 months of this Act. In our impact assessment, the Government has set out its initial plan for monitoring and evaluation of the impacts of the bill, as well as in secondary legislation. And I say this with the greatest respect to the Honourable Lady. She has put forward some concerns about the business burden, but if we had accepted all her party's amendments yesterday, that would have added several £billion to the costs of businesses. So I do say to the Liberal Democrats, they have to decide, really, ideally tonight, whether they are in favour of workers' rights or not. Turning now to some amendments from the official opposition. Amendment 297 seeks to increase from 7 days to 14 days the notice period that trade unions are required to adhere to when notifying employers that they plan to take industrial action. Our consultation on creating a modern framework for industrial relations sought views on what an appropriate notice period for industrial action would be, recognising that the repeal of the Trade Union Act 2016 would reduce the notice period from 14 to 7 days. The Government has listened carefully to concerns from respondents to that consultation that a 7-day notice period would not be enough time to prepare for industrial action in some important sectors, such as transport, healthcare and education, with potential knock-on impacts on other services. The Government believes that employees should be given sufficient time to mitigate against the most severe effects of industrial action, and acknowledges responses to the consultation that argue that 7 days' notice was insufficient. Of course, we did have 7 days' notice between 2010 and 2016 under the previous Tory government, and it does show really the lack of understanding of this bill from the number of times we heard that this bill was going to take us back to the 1970s. It is going to take us back to 2015 when this bill was previously introduced, and the Government's view is that 10 days is in fact the appropriate balance in allowing employers the ability to mitigate the impact of industrial action and reduce disruption and the knock-on impacts of strikes, whilst of course respecting the right to strike. Turning now to Opposition Amendment 291, which seeks to remove Clause 52 on political funds. I think we've had probably the most heated debate in respect of that particular amendment, and of course it's noted that when it comes to reducing Tory red tape, it's only trade unions who don't have the same benefits that everyone else does. And it is important to note that there's been, I think, a fundamental misunderstanding about what a trade union is. It is a member-based democratic organisation designed to protect those who are part of it. Comparisons with Netflix subscriptions and insurance contracts are bogus because they are not the same thing at all. Membership of a trade union and a political fund is not a subscription that you sign up for a fixed period. It is membership of a democratically organised independent trade union, which you are free to leave at any time. The members have control of the organisation because it is democratically organised, and they can decide as a union whether to have a political fund at all. You cannot email the chief executive of Netflix and demand that they make a programme starring your favourite actor, but if you're unhappy with the trade union, you have the opportunity to get involved and change it. And it should be noted that in the 40 years that we've had political fund ballots, no union has disaffiliated from the Labour Party as a result of that. There's been no closure of political funds. So it's very clear that this is simply red tape. And of course, it isn't all about funding the Labour Party, because more than nearly half of all unions don't even have affiliation with the Labour Party who actually have a political fund. So, and of course, if the members opposite aren't satisfied with that, they should actually read the bill that's before them, because the clause that they want to remove, clause 52, sets out at subsection 8 how the members can actually opt out of the political fund. It even says the ways you can do it: by post, email or electronic means. I have to say, some of the patronising comments we've had that people will be trapped into something that they don't wish to be in does not reflect the reality of the situation or the ability of trade union members to make up their own minds and exercise their democratic rights. And if any of them opposite had actually ever been members of a trade union, they would understand that. And I have to say, I think the repeated insinuations from members opposite that I or anyone else on these benches have brought this bill because we have been paid by the trade unions to do so is both offensive and wrong in equal measure. They might think money buys you the chance to write the law, but that says far more about their approach to legislating than ours. on these benches, we do these things because we believe in them. We believe everyone deserves fair treatment at work, and this bill delivers on that. It is delivering on our values. So, in conclusion, Madam Deputy Speaker, this is a generational shift in protection, a long overdue reinforcement of workers' rights in this country, and tangible proof of how a Labour government can bring meaningful benefit to people's lives. For many of us, it is fundamental as to why we are in the Labour Party. So now is not the time to shy away from our efforts. Now is not the time to talk about what might have been, but it's a time to be bold, to be loud and be proud that this Labour government is delivering by putting fairness, dignity and security back into the workplace.
The question is that new clause 39 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. No. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Anna Turley, Kate Durden. Tellers for the noes, Paul Holmes, Jerome Mayhew. Order.
The ayes to the right, 337. The noes to the left, 98.
The ayes were 337, the noes were 98, so the ayes have it, unlocked. The question is that new clause 39 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, We now come to Government New Clause 40. I call the Minister to move New Clause 40 formally.
Move formally.
Parliament to pass political resolution.
The question is that New Clause 40 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, The question is that New Clause 40 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, We now come to Government New Clause 41. I call the Minister to move New Clause 41 formally.
Move formally.
Industrial action ballots, support thresholds.
The question is that New Clause 41 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, The question is that New Clause 41 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, We now come to Government New Clause 42. I call the Minister to move New Clause 42 formally.
Move formally.
Notice of industrial action ballot and sample voting paper for employers.
The question is that New Clause 42 be read a second time. As many as are of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, The question is that New Clause 42 be added to the bill. As many as are of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, We come to Government New Clause 43. I call the Minister to move New Clause 43 formally.
Move formally.
Period after which industrial action ballot ceases to be effective.
The question is that New Clause 43 be read a second time. As many as are of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, The question is that New Clause 43 be added to the bill. As many as are of that opinion say aye. Aye. On the contrary, no. I think the ayes have it, We come to New Clause 44. I call the Minister to move New Clause 44 formally.
Move formally.
Power to give notice of underpayment.
The question is that New Clause 44 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, The question is that New Clause 44 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, We now come to Government New Clause 45. I call the Minister to move New Clause 45 formally.
Move formally.
Calculation of the required sum.
The question is that New Clause 45 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, The question is that New Clause 45 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, We now come to New Clause 46. I call the Minister to move New Clause 46 formally.
Move formally.
Period to which notice of underpayment may relate.
The question is that New Clause 46 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, The question is that New Clause 46 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, We come to Government New Clause 47. I call the Minister to move New Clause 47 formally.
Move formally.
Notices of underpayment, further provision.
The question is that new clause 47 be read a second time. As many as are of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 47 be added to the bill. As many as of that opinion say aye.
Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 48. I call the Minister to move New Clause 48 formally.
Move formally.
Penalties for underpayment.
The question is that new clause 48 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 48 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 49. I call the Minister to move New Clause 49 formally.
Move formally.
Further provision about penalties.
The question is that new clause 49 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 49 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 50. I call the Minister to move New Clause 50 formally.
Move formally.
Suspension of penalty where criminal proceedings have been brought, etc.
The question is that new clause 50 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 50 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 51. I call the Minister to move New Clause 51 formally.
Formally.
Appeals against notices of underpayment.
The question is that New Clause 51 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 51 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 52. I call the Minister to move New Clause 52 formally.
Move formally.
Withdrawal of notice of underpayment.
The question is that new clause 52 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 52 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 53. I call the Minister to move New Clause 53 formally.
Move formally.
Replacement notice of underpayment.
The question is that new clause 53 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 53 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 54. I call the Minister to move New Clause 54 formally.
Move formally.
Effective replacement notice of underpayment.
The question is that new clause 54 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 54 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 55. I call the Minister to move New Clause 55 formally.
Move formally.
Enforcement of requirement to pay sums due to individuals.
The question is that New Clause 55 be read a second time. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. The question is that New Clause 55 be added to the bill. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 56. I call the Minister to move New Clause 56 formally.
Move formally.
Enforcement of requirement to pay penalty.
The question is that new clause 56 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 56 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 57. I call the Minister to move New Clause 57 formally.
Move formally.
Power to bring proceedings in Employment Tribunal.
The question is that New Clause 57 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 57 be added to the bill. As many as are of that opinion say aye. Aye. On the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 58. I call the Minister to move New Clause 58 formally.
Move formally.
Power to provide legal assistance.
The question is that new clause 58 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 58 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Clause 59. I call the Minister to move New Clause 59 formally.
Move formally.
Recovery of costs of legal assistance.
The question is that New Clause 59 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 59 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We now come to Government New Clause 60. I call the Minister to move New Clause 60 formally.
Move formally.
Power to recover costs of enforcement.
The question is that new clause 60 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. The question is that new clause 60 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. New clause 110 has been selected for separate decision. I call Daisy Cooper to move new clause 110 formally.
Move formally.
Review into the impact on small businesses.
The question is that new clause 110 be read a second time. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Zoe Franklin, Charlie Maynard. Tellers for the noes, Anna Turley, Kate Dearden. Order, order.
The ayes to the right, 168. The noes to the left, 314.
The ayes were 168, the noes were 314, so the noes have it, the noes have it. Unlock. With leave of the House, I shall put a single question on Government Amendments 162 to 185. I call the Minister to move Amendments 162 to 185 formally.
Move formally.
The question is that Government Amendments 162 to 185 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it, the ayes have it. Amendment 291 has been selected for separate decision. I call the opposition spokesperson to move the amendment formally.
Formally.
The question is that Amendment 291 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. No! Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Paul Holmes, Jerome Mayhew. Tellers for the no, Anna Turley, Kate Jaden. Order.
The ayes to the right, 164. The noes to the left, 324.
The ayes were 164, the noes were 324. So the noes have it, the noes have it. Unlock. With the leave of the House, I shall put a single question on Government Amendment 186 to 201. I call the Minister to move Amendments 186 to 201 formally.
Move formally.
The question is that Government Amendments 186 to 201 be made. As many as are of that opinion say aye. Aye. The contrary, no. I think the ayes have it. The ayes have it. Amendment 297 has been selected for separate decision. I call the opposition spokesperson to move amendment formally.
Formally.
The question is that Amendment 297 be made. As many as are of that opinion say aye. Aye. The contrary, no. No! Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Paul Holmes, Jerome Mayhew. Tellers for the noes, Anna Turley, Kate Dearden. Order, order.
The ayes to the right, 167. The noes to the left, 328.
The ayes were 167, the noes were 328, so the noes have it, unlocked. Order, order. Under the order of the House of 11th of March, I must now put the question necessary to bring proceedings on consideration to a conclusion. I call the Minister to move amendments 202 to 239 formally.
Move formally.
The question is that Government Amendments 202 to 239 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. We come to Government New Schedule 2. I call the Minister to move New Schedule 2 formally.
Move formally.
The question is that New Schedule 2 be added to the bill. As many as are of that opinion say aye. Aye. Of the contrary, no. No! The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tell us for the ayes, Anna Turley, Kate Dearden. Tell us for the noes, Paul Holmes, Jerome Mayhew. Order.
The ayes to the right, 333. The noes to the left, 100.
The ayes were 333, the noes were 100, so the ayes have it, the ayes have it. Unlock. I call the Minister to move amendments 246 to 263 formally.
Move formally.
The question is that Government Amendments 246 to 263 be made. As many as are of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. Consideration completed. Third reading. Now. King's consent. Minister to move third reading. Secretary of State Angela Rayner.
Thank you, Madam Deputy Speaker. I beg to move that the bill be now read a third time. And I refer honourable members to my register of interest and declare that I'm a lifelong proud trade unionist. Let me begin by thanking right honourable and honourable members on both sides of the chamber for their positive and constructive engagement over recent months. And in particular, Madam Deputy Speaker, I want to thank the superhuman work of my honourable friend, the member for Ellesmere Port, in steering this bill through its common stages, and all the members of the Bill Committee for their thoughtful scrutiny. Madam Deputy Speaker, when this government took office, we promised the biggest upgrade to workers' rights in a generation, nothing less than a New Deal for working people. We said that we'd introduce a bill to deliver that within 100 days, and we've heard from those opposite who said we shouldn't, and there were those that said we couldn't, but we did. And today this House is taking another giant step towards making work pay. Because let's be clear, too many working people have had to wait for too long for change. Over a decade, wages flatlined, in-work poverty grew, and growth was strangled. We inherited a failing economy which served no one. But today, a government of working people for working people is turning the tide. This landmark bill, pro-growth and pro-business and pro-worker, will put fairness back in work. Almost 9 million employees will be protected from unfair dismissal. Up to 2 million will receive a right to bereavement leave. And 1 million workers on zero-hour contracts will get the security that they deserve. And in 3 weeks' time, Madam Deputy Speaker, over 3 million workers will see one of the biggest rises in the minimum wage on record. We said that we would make work pay, and this government meant it. And our vision is backed by many of the best businesses, like the 1,200 members of the Good Business Charter, from FTSE 100 companies to small and medium enterprises. They prove that if you treat people well, you get the best out of them. They know that being pro-worker isn't a barrier to success, it's a launch pad to it. And that's why this bill takes the very best standards from the very best businesses and extends them to a million more workers. And that's why we proudly say that this is a pro-business and pro-worker bill. But we know, Madam Deputy Speaker, that this will represent change, and I understand that many businesses want to work with the government to get the details right. And our commitment in the weeks and months ahead is to do just that. But, Madam Deputy Speaker, my message is clear. This transformative package is a huge opportunity, a once-in-a-generation chance to reshape the world of work and to drive a race to the top on standards, and to deliver growth and build an economy that works for everyone. We know the Tories, in lockstep with reform, will fight this every step of the way. Over 2 decades ago, they did the same with Labour's minimum wage. They said then that it would destroy 2 million jobs, and now they're queuing up to vote against every single measure in this bill. But the truth is, Madam Deputy Speaker, they were wrong then and they are wrong now. The only thing that they are consistent on is that every time they have had the chance to deliver basic fairness for workers, they have voted against it. We know that they can't be trusted to stand up for working people, but this Labour government will. Because for too long, people in Britain have been overlooked and undervalued, and our plan changes that. With jobs that are more secure and family-friendly, with women supported in work in every stage of life, with a genuine living wage and sick pay for the lowest earners, with further and faster action to close the gender pay gap, with rights that are enforced, with trade unions that are strengthened. Madam Deputy Speaker, in July, after 14 years of failure, the country voted for change. We promised to deliver a new deal, and today this Labour government delivers on that promise, with a once-in-a-generation transformation to build an economy based on fairness, to raise living standards and to drive growth, and deliver a better Britain for working people. And I commend this bill to the House.
The question is that the bill be read the 3rd time. I call Shadow Minister Andrew Griffith.
Thank you, Madam Deputy Speaker. Before I summarise the opposition's view on this bill, I'd like to pay tribute to those on our benches who've contributed during its passage. My honourable friend, the member for Mid-Buckinghamshire, has held the government to account with forensic skill at the report stage and in the Bill Committee. He was joined in that Bill Committee by my honourable friends, the member for West Suffolk, Bridgewater and Mid-Leicestershire, and the members for Bognor Regis and Littlehampton and Dumfries and Galloway performed great service as members of the Select Committee. I also acknowledge the work of officials in the Department and in Parliament. Their job cannot have been easy, given the indecent haste with which this bill has been produced. Now, Madam Deputy Speaker, while we disagree on much, it would be churlish not to represent today represents a personal victory for the Deputy Prime Minister. Whilst the Business Secretary and the Chancellor lie low, there's no doubt who's been in the driving seat. Well, he is now. He's here now. Madam Deputy. Madam Deputy Speaker. Madam Deputy Speaker. It's very...
Order. Shadow Minister.
We welcome him to his place. Madam Deputy Speaker, whilst at least the Deputy Prime Minister is honest in her unwavering support for the trade union agenda. She's proud to walk in the footsteps of Neil Kinnock, Michael Foot and the Right Honourable Member for Islington North. A conviction politician in the proper sense of the word, not a politician with convictions like the Labour MP for Runcorn. It makes a welcome change. It makes a welcome change. It makes a welcome change. Well, he's going. It makes a welcome change from a Prime Minister who pretends this bill is about growth. It's not easy for the Right Honourable Lady. It's always awkward being at odds with your boss. He says grow, you say slow. He wants fewer regulators, you create new ones. We all remember how in 2021 she herself was a victim of fire and rehire by a bad boss. Just wait until he sees the higher unemployment, higher prices and lower growth that this bill will bring.
Order. Shadow Minister.
I'll do that again. The higher unemployment, the higher prices and the lower growth in this bill. No wonder the Right Honourable Lady is in favour of making it harder to be sacked. But, Madam Deputy Speaker, this is a... It's your own time. This is a sad day for business and a bad day for Parliament. Business will have watched the last 2 days with dismay. They'll watch this with dismay as well, Madam Deputy Speaker. As they struggle with the Chancellor's job tax and business rates hike about to hit next month, they see hundreds of pages of red tape heading their way. They will have seen the Minister yesterday asked to name a single small business who supports this bill, reel off the names of 3 large ones, 2 of which turned out not to support it anyway, and the third was a quote from the Chief Inclusion Officer at the Co-op. My honourable friend, the member for Wetherby, put it well yesterday when he said this government plans to increase the number of small businesses by starting with large ones and making them smaller. And no one who cares about Parliament legislating well can be proud of how we got here. A rushed bill which was introduced at half the length to which it has now grown. An impact assessment which the Regulatory Policy Committee described as not fit for purpose. Over 260 pages of amendments, few of which were scrutinised at committee. And speeches in favour which have leaned heavily in support of the trade unions who stand to gain so much financially from this bill. But Madam Deputy Speaker, my final word goes to the real... I can do some more. The final word goes to the real victims. They don't want to hear it, Madam Deputy Speaker. The real victims of this bill. Faced with this legislation, employers will take fewer risks on new employees. As a result, this bill will disproportionately hit young people the hardest. They don't have the track record to rely on someone giving them the chance, a first step into the world of work. Unlike so many of those opposite, whose first job was at a comfortable desk in Trade Union Congress House, my first job was at a supermarket. That company was able to take a risk on a young Andrew Griffith with no career experience. They were able to take that chance because they knew I couldn't start work in the morning and then file an employment tribunal claim in the afternoon. I know for many Labour cabinet members, career experience in their CV is a sensitive topic, but that does not excuse what is a vindictive attack on the next generation. Madam Deputy Speaker, the truth is Labour don't understand business. They don't understand what it takes to grow. They never have, and they never will. Every Labour government has left office with unemployment higher than when they started. And that is why we cannot support this terrible bill.
The question is that the bill be now read the 3rd time. As many as are of that opinion say aye. Aye! Of the contrary, no. No! Division, clear the lobby. The question is, as on the order paper, as many as are of that opinion say aye. Aye. Of the contrary, no. No. Tellers for the ayes, Kate Dearden. Anna Turley. Tellers for the noes, Paul Holmes, Jerome Mayhew. Order, order.
The ayes to the right, 333. The noes to the left, 100.
The ayes were 333, the noes were 100, so the ayes have it, unlocked. I'll now give a few moments for the chamber to settle down.